Okay, I think we're ready to get started. If everybody would like to have a seat, appreciate it. Well, good morning. I want to thank all of you for being here today on the Roundtable on International Issues relating to Title VII of the Dodd-Frank Act. I'm going to make a few opening remarks and allow my colleagues at the CFTC and SEC to do the same before we start panel one. The CFTC has been hard at work proposing rules required to implement Title VII of the Dodd-Frank Act relating to swaps oversight reforms. We've heard from the industry in formal and informal comment about international issues and concerns relating to implementation of the Dodd-Frank Act. We look forward to your input on not just the issues, but also potential solutions. Although each of our agencies has different statutory provisions regarding the international reach of Title VII, we have a similar need to address the scope of our reach. 722D of the Dodd-Frank Act states that provisions of the Act relating to CFTC-regulated swaps shall not apply to activities outside the U.S. unless those activities, one, have a direct and significant connection with activities in or effect on commerce of the U.S., or two, contravene the rules and regulations promulgated by the CFTC as necessary or appropriate to prevent evasion of the Dodd-Frank Act. I realize the swaps industry is waiting for guidance on this provision, as the CFTC's application of it is important in light of the global nature of the swaps market. The CFTC has a history of working out solutions to international issues. For example, for many years, we have relied on foreign regulators to regulate foreign intermediaries and exchanges if they have comparable regulation. These programs are based in part on the fact that the participants, the products, and the infrastructure involved are all foreign. The swaps market is more complex. Moreover, we have different, in some cases, more limited authority to provide exemptions or recognition abroad under Title VII. Before I turn it over to Dan Berkovitz, I would like to give a short review of the day. We have three panels that will consider the international issues relating to the Dodd-Frank Act. Panel 1, cross-border transactions. The first panel is intended to address issues relating to when transactions should be subject to U.S. regulation. In this regard, it will be helpful to hear from panel members on how our respective agencies should define the words direct and significant as used by 722D of the Dodd-Frank Act. We also want to see if it would be useful and necessary to define U.S. persons, and if so, how should we define U.S. persons? Finally, there are certain things that apply to all persons under the Dodd-Frank Act, including clearing, trading, and reporting, and we would like to hear about those requirements under this panel. The second panel, although is similar to the first panel, is regarding global entities. We hope to ask panelists about issues at the level of activity that would have a direct and significant effect on U.S. commerce, thus triggering registration as a swap dealer or major swap participant. There are specific issues we'd like to hear about relating to subsidiaries, branches, and affiliates of U.S. firms and the requirements that should apply. And finally, panel 3 on market infrastructure. It's our final panel, and we want to cover clearinghouses, trading venues such as swap execution facilities and security swap execution facilities and foreign exchanges, and trade repositories. With respect to all types of market infrastructure, we are interested in your views on the differences in regulatory requirements that would make it difficult or impractical for a global entity to comply with both U.S. and foreign requirements, and whether there are competitive issues or concerns that we should take into account. So we have a lot of material to cover, and I look forward to today's discussion. I appreciate the thoughtful comments we've received so far, and now I'll turn it over to Dan Berkovitz for some comments.
Good morning, and thank you, Jackie. Good morning, panelists, my colleagues at the CFTC and the SEC, and members of the public. Before I provide a few remarks, I'd like to thank the staffs of both commissions, both the CFTC and the SEC, for organizing today's roundtable. I'd also like to thank the panelists for agreeing to participate, sharing their perspective, and taking the time to participate on the panel today as we discuss the extraterritorial application of the new regulatory landscape for swaps transactions under the Dodd-Frank Wall Street Reform and Consumer Protection Act. Since the passage of the Act, CFTC staff has held many meetings with market participants and received hundreds of comment letters, many of which have focused on the extraterritorial application of the Act and the CFTC's rules promulgated thereunder. Under our transparency policy, comment letters and summaries of these meetings are all posted on the CFTC website. During these meetings and in the comment letters, market participants have raised concerns regarding how the United States and other jurisdictions will apply supervisory or regulatory responsibilities for swap entities, trading platforms, trade repositories, and swaps transactions that span multiple jurisdictions. I can assure you that both commissions are working diligently to implement needed reforms in the swaps market and are actively consulting and coordinating with each other and international regulators to promote robust and consistent standards. In Morrison v. National Australia Bank, the Supreme Court took note of the long-standing principle of American law that unless Congress clearly expresses an affirmative intention to give a statute extraterritorial effect, quote, we must presume it is primarily concerned with domestic conditions, unquote. The Dodd-Frank Act expresses clear congressional intent that it apply to certain extraterritorial activities. Section 722D of the Dodd-Frank Act states that the provisions of the Act relating to swaps shall not apply to activities outside the U.S. unless those activities have, quote, a direct and significant connection with activities in or effect on commerce of the United States, or those activities are intended to contravene the Act or the CFTC's regulations promulgated thereunder. A key inquiry, therefore, is to determine which activities outside the U.S. meet these tests. This is not our only inquiry, however. As the Commission noted in the proposed rule regarding registration of entities, considerations of international comity also play a role in determining the proper scope of extraterritorial application of federal statutes. We must also consider the circumstances in which international comity may affect the application of Dodd-Frank provisions extraterritorially, and how such considerations will affect the application of the Act outside the U.S. I am hopeful that today's roundtable will help inform the Commission not only on the panelists' views of the ultimate questions of how Dodd-Frank should apply extraterritorially, but also of the process that the Commission should use to make these determinations. I personally am co-moderating today's second panel, which will focus on global entities. In several comment letters filed in response to the CFTC proposals defining and registering swap dealers and major swap participants, commenters have emphasized the importance of establishing an appropriate regulatory framework for the cross-border swaps activities of U.S. and foreign banks. The CFTC recognizes that defining the scope of the Dodd-Frank Act with respect to the cross-border activities of U.S. and foreign banks is crucial to preserving the continuity of global business operations and the risk management tools that swaps provide. It is necessary that we accomplish the overall objectives of improving transparency, mitigating systemic risk, and protecting against market abuse in the swaps markets. And with these objectives in mind, we are asking these questions regarding extraterritorial application. Today's roundtable will play a significant part in achieving these objectives. That is why I look forward to our dialogue on these important issues, and I'm confident that the staff will be informed by the remarks of today's panelists. Thank you very much.
Thanks, Dan. Now I'm going to allow Ethiopius Tafara, Director of the Office of International Affairs at the SEC, to also provide some remarks.
Good morning. I'm Ethiopius Tafara, Director of the Office of International Affairs at the SEC. And on behalf of the SEC staff, I'd like to welcome you to this joint SEC-CFTC roundtable on international issues relating to the implementation of Title VII of the Dodd-Frank Act. I'd like to start off by thanking my colleagues here at the CFTC for hosting today's roundtable, and the staff at the CFTC and the SEC who tirelessly worked together in organizing the program. I also would like to thank all of the panelists for their participation in today's discussion. We appreciate your willingness to be here and to share your thoughts and perspectives on the cross-border issues arising from Title VII of the Dodd-Frank Act. These roundtables are immensely helpful as they give us the opportunity to hear firsthand how our rulemaking activities may impact you, the market participants, investors, and other members of the public. In turn, your comments will assist in developing approaches that will enhance the efficiency of the cross-border derivatives market while advancing our mission of protecting investors, ensuring the maintenance of safe, fair, and honest markets, and facilitating capital formation. Before I make a few remarks about today's roundtable, I'd like to remind everyone that the views we express today are our own and do not reflect the views of the Commission, the Commissioners, or our fellow staff members, and I think that should apply throughout the day for all of us from the regulatory agencies. The purpose of the roundtable is to explore the international issues raised by new CFTC and SEC rules to regulate the swaps and securities-based swap markets. The interconnection of markets around the world has opened a new frontier. It is true that our capital markets have always had an international component and that cross-border transactions have always been with us. But it's the exponential advances in computer and telecommunication technologies that have altered the dimension. The promises of this new frontier are many. These promises include lower transaction costs, greater choice, and greater competition among financial service providers to the benefit of end users. But this new frontier also presents risks. We must keep in mind that as national markets become integrated, global risks become domestic risks. The cross-border consequences of the Asia crisis of '97 and the more recent subprime crisis are evidence of that fact. Previous regulatory approaches to cross-border financial services were devised when the world was a different place and markets were more self-contained and isolated from the outside world. One approach for dealing with this new environment is isolation. We can try to seal our borders. Much like the sheriffs of old required all strangers to check in upon arrival, we can insist that all entities, whether foreign or domestic, providing financial services or products, come fully under our regulatory control in every detail. We might also be tempted to open up the town gates, let everyone in who wishes to do business with our citizens declare caveat emptor and accept the resulting playing field. Neither of these approaches is economically efficient, and both seriously test our ability to meet our regulatory charge. International collaboration is a third and likely better alternative. We're well aware that we will be regulating a market that is already global in nature. First, the main players in the market are global. Currently, large banks and other financial institutions dominate the derivatives markets. These firms have offices, branches, subsidiaries, and affiliates in multiple jurisdictions and serve clients and customers around the world. At the same time, key market infrastructure entities, such as exchanges and trading platforms and clearinghouses, increasingly serve an international customer base and compete on a global level. Second, a large portion of the derivatives transactions engaged by U.S. persons is cross-border. Federal Reserve economist Sally Davies estimated in her 2008 study that 55 to 75% of U.S. banks' total exposure to derivatives involved counterparties resident outside the United States. More recent data from the Bank for International Settlements support the conclusions that cross-border exposure remains at the same levels today, if not higher. Third, we recognize that one of the great advantages of derivatives products is that derivatives can offer investors exposure to almost any type of asset and in almost any market without the need to take possession of such assets or be fixed in a certain location, and often at a lower cost. It is this flexibility that makes derivatives such popular financial instruments. Thus, we face a challenge in regulating derivatives. We believe, and Congress is determined in the Dodd-Frank Act, that the size and importance of the derivatives markets require robust regulation. Such regulation will improve transparency, market efficiency, investor protection, and financial stability. However, the global nature of derivatives markets means that entities around the world have the ability to significantly impact the U.S. financial markets. Let me conclude my opening remarks by noting that while our roundtable consists only of members of the public and market participants, the SEC and CFTC are actively speaking with foreign counterparts about many of the same issues being discussed today. As you know, pursuant to the G20 commitment regarding the clearing, reporting, and trading of standardized OTC derivatives contracts by the end of 2012, many foreign jurisdictions are also drafting legislation and implementing rules relating to derivatives. The Dodd-Frank Act notes the importance in working to ensure that the U.S. and other countries' regulatory regimes are based on the same robust international standards, and to that end requires the SEC and the CFTC to consult and coordinate with foreign regulators on the establishment of those standards where possible. In the last year, the SEC and CFTC have engaged in regular discussions with foreign counterparts on a bilateral basis and through multilateral fora, such as the IOSCO Task Force on OTC Derivatives Regulation, which is currently drafting international standards for derivatives regulation in the area of clearing, reporting, and intermediary oversight. Our goal is to develop a comprehensive approach to international issues raised by Title VII that strikes a balance between facilitating a robust and active global derivatives market while remaining faithful to the spirit and letter of the Dodd-Frank Act and vigorously upholding our mandate to protect investors and preserve the integrity of our markets. Today's roundtable should help inform our work. I again would like to thank our distinguished panelists for their participation. The insights that you provide today will be extremely valuable to us as we finalize our implementation of Title VII. Thank you.
For final remarks, I'd like to introduce Robert Cook, who is Director of Trading Markets at the SEC.
Thank you, Jackie, and good morning. I'm joined today by Brian Bussey, who heads up our Office of Derivatives Policy and Trading Practices at the SEC in the Division of Trading and Markets. I'd just like to briefly echo the thanks that have already been given to our panelists for taking their time to join us today. We very much look forward to your insights and recommendations. Also, to echo the thanks to the CFTC for hosting this event and to the staffs of the two agencies for organizing it, I'd just like to make two very brief remarks before we begin. One is that from our perspective, one of the key areas that we look forward to hearing discussion on is the detailed application of our rules under Title VII to what I'll call cross-border transactions. So more specifically, how the registration, reporting, mandatory clearing, and mandatory trading requirements should apply to securities-based swap transactions that involve a U.S. counterparty, a U.S. intermediary, or that otherwise involve the U.S. jurisdictional means. Second, we recognize the uncertainty that currently exists in this area and, frankly, the difficulties that places some of the international institutions who have operations in various jurisdictions in trying to plan for the future. The chairman of the SEC has stated in recent congressional testimony that the SEC intends to address the relevant international issues holistically in a single proposal, which we're actively working on. This will allow market participants to comment on our proposed approach to cross-border transactions involving the U.S. as an integrated whole. The roundtable discussion today will help inform our thinking regarding this proposal, as will the various comments that we very much appreciate having received to date through our SEC mailbox. I believe there's also a comment file that's been opened in connection with this roundtable that people should feel free to submit comments to help inform the thinking of both agencies. So again, thank you for joining us today, and we look forward to your participation.
Thank you. Well, welcome, Panel 1. I would just like to take a moment for you to do self-introductions. If you could just introduce who you are and who you're with, and then we'll formally get started. Can we start right here at the end with you? Yeah.
I'm Bob Riley from Shell Trading, and as of last Friday, Shell had 1,144 subsidiaries operating in 105 countries. So extraterritorial issues and issues involving inter-affiliate transactions, very important to us. Thank you for letting me be here today.
Thank you. And just also as a reminder, if you can speak into your microphone, that'll help the whole room to hear.
John Nicholas, New Age. Thank you.
Bill Mansfield with Rabobank, a global bank located in the Netherlands. I'm responsible for the capital markets activities and the financial market activities in the Americas region.
Dennis Klena, MF Global.
David Kelly from UBS.
Tom Riggs from Goldman Sachs.
Marcus Stanley, Americans for Financial Reform.
Wally Turbeville, Better Markets, a nonprofit, nonpartisan organization whose mission is to express the public interest in regard to reform.
Luke Zubrod, Chatham Financial. Chatham is an advisor to about 1,000 end users in the U.S., Europe, and Asia.
And one person who didn't get a formal introduction is sitting on my left is Ananda Radhakrishna, who is director of our Clearing and Intermediary Oversight Division. So, for panel one, I made some introductory remarks earlier that I think what is important regarding cross-border transactions, perhaps as a first step, is whether or not the CFTC and SEC need to have a definition for U.S. persons. Many of the rules may relate to whether or not you are a U.S. person. I think there are differing definitions of U.S. person in the SEC, for the SEC and the CFTC. So my first question is, first, do panelists think that we need a definition for U.S. person? And if we do, what is your recommendation for that definition? And if you would like to speak, just put up your placard like this and I can call on you. Thank you. John?
Thanks, Jackie. Yeah, I think it would be useful to have a definition of U.S. person, but I think you hit the nail on the head when you noted that the SEC and CFTC have already have different definitions. I believe the SEC under Reg S has one definition, which I also think is used for 15A6 purposes, and then the CFTC has another definition. Two comments in that respect. One is I think it would be useful to the extent possible to try to harmonize the definitions. I know that's harmonization of the securities and futures laws is one of the dictates that we're supposed to follow. The other one is, I think that in general the definition should take into account the differences between funds and non-funds. Funds having a potentially to the extent there's a look-through requirement, that it be a relatively low threshold, and to the extent that there's not a look-through requirement, that it be based on the headquarters of the entity. Thanks.
Wally?
The question of whether there should be a definition or not, just going back to that, it could be measured by what's convenient for folks in the business. Should also needs to be looked at in the context of the statute, which is, to me, the real guiding light as opposed to convenience, although convenience is an important thing, of course. And I sort of look at sections 722 and 772, I guess, of the statute. And it seems to me that one might look to those provisions as for guidance and definition. 722, which relates to CFTC, describes activities that have a direct and significant connection with the activities in or effect on commerce of the U.S. That would suggest to me that activities-based analysis is quite important. 772 is somewhat different and talks about business being conducted in securities-based swaps without the jurisdiction, beyond the jurisdiction of the U.S. So it's a business-based orientation. So I'm curious as to whether folks while it might be convenient to categorize jurisdiction by the way companies are organized, it would seem to me is more likely to be productive under the terms of the statute by looking at what their activities are, what their business is, and whether a company is organized a certain place may not be so relevant as what their activities are and what their businesses are. For instance, a parent who guarantees all the activities of a subsidiary who may be non-U.S. based and combines all of the swaps in a common book, uses common systems and management, those kinds of things. All those to me would be indicia of what the statute was intended to govern, and show that the the whole purpose may be very different from other statutes, other regulatory regimes, the Fed, other things the SEC and the CFTC have done. So I would sort of go back to those sections and look at what's substantively going on.
I thank you. First of all, we do need a definition, obviously. Since the SEC and the CFTC already have definitions, I assume that you would work with what you have and not start from scratch. I think it's important, and I know you guys are very focused on this, the definition for futures and securities have existed with differences because those markets are quite different. Now, if you have a single name credit derivative and an index credit derivative with the same counterparty under the same agreement, to be a U.S. person for one of the transactions, not a U.S. person for the other transaction, obviously is just not tenable. So it puts a high priority more than ever on the SEC and the CFTC harmonizing that definition. And more importantly as well, whatever the definition is, it needs to be harmonized internationally because so you don't fall in a situation where someone's a U.S. person for U.S. rules and also a European person for the European rules. And again, we get back to the issue of having potentially conflicting multiple sets of rules applying to the same person.
Luke?
End users are primarily concerned with being able to continue to efficiently and effectively manage their risks. And I think contributing to that cause is being subject to a single set of clear rules to the extent practicable in any given circumstance. So I think clearly defining U.S. person will contribute to this clarity, though international coordination is also essential for the purposes of achieving harmony in the absence of duplicativity. I think at a minimum, we believe it would be helpful to clarify what does not constitute a U.S. person. A foreign subsidiary of a U.S. person should not be a U.S. person if it has no significant connection to the U.S. And we believe it's important that the mere ownership or guarantee by a U.S. parent should not form the sole basis for determining that a foreign subsidiary has a significant connection to U.S. law. It's important that U.S. law acknowledge that many U.S. companies set up foreign subsidiaries not for the purposes of evasion, but rather because it makes good business sense just in operating a regular business. These subsidiaries may be physically located abroad, have business operations abroad, etc., and will thus be subject to regulatory requirements from foreign regulators. And I think one important guiding principle should be that if you're subject to regulation elsewhere, you shouldn't be subject to a regulatory regime, the U.S.'s regulatory regime as well. Though I think an important consideration in establishing this principle is working through timing considerations. To the extent that the U.S., as seems likely, will initiate the regulatory or its regulatory regime will become effective. First, the fact that other countries, other jurisdictions have not yet completed their regulations should not de facto then subject that entity to U.S. law. So I think sort of coming up with a mechanism that accommodates timing differences relative to the implementation of regulations in multiple jurisdictions is important.
That's a big issue for us, or for me anyway, because basically, and this argument has been made before, right? Wait until country X finishes. What that means is that if we did that, we are going to peg ourselves to the last person, the last jurisdiction that finalizes its rules. And so the concern we have is, you've got a statute out there, you've got obligation to finish regulations in 1 year, which we didn't do. But still, it doesn't mean that we're not going to finish it. So why should we wait? That's a critical question. Why should we wait until country X, country Y finishes it 5 years down the road? Because then the momentum goes away. Now, I realize some of you want that momentum to go away, and then that's fine. But, from our perspective, we can't let it go away. So,
I would certainly acknowledge that that's a complicated process to figure out how to implement this, but I think it's important to note that many of the activities that could be subject to regulation in foreign jurisdictions either have limited or no connection to U.S. law and to the mitigation of systemic risk. And so I think balancing the desire to have a robust regulatory framework should also be in tension with the desire to ensure that end users are not subject to regulation that does not contribute materially to the mitigation of systemic risk.
Marcus?
I just wanted to respond to that by saying that it's a good thing to avoid duplicative or multiple regulatory regimes, and where it's possible, it should certainly be done, but it's not a statutory goal as I see it. And the goals of the statute are pretty clear and to me should take precedence over in some of these issues, and that's protecting the U.S. economy from risk and from exposure. And one thing, this issue of foreign subsidiaries has also come up, of course, in margin requirements and in comments on the prudential regulators' rules. And one thing I don't see in these comments is any explanation of how the U.S. parent is protected from losses in the subsidiary. I mean, to me, if the U.S. parent is going to be responsible for the subsidiary's losses, that's a connection to the U.S. economy right there. I mean, we've seen international derivatives. We've seen derivatives losses spread internationally before. And just in comment on the timing, to reinforce what the gentleman at the end said, it seems to me there's a certain first mover advantage here. If you can be the one to get out the details of your rules first, then there may be a tendency for other countries to follow you. And I'm an America First kind of guy, so I think there are some advantages of that, especially when we're looking at a situation where the whole G20 committed in 2009 to really a similar set of conceptual goals. So we're all following the same path here, and there might be advantages to getting the details of that path in, to be the first to get the details of that path in.
Bill?
Yeah, just a comment back to not waiting for the rest of the world. I think that's a legitimate concern, but I also think that these rules are complex. I think the international markets are complex. I think we need to do it carefully. I think we need to take our time. I think the U.S. regulators can set the standard with regards to how they expect swaps to be regulated and derivatives to be regulated, and they can watch the rest of the world follow suit or not. And if they don't, it's within your purview to further broaden your scope. So, legitimate concern, but I do think that we need to carefully implement these rules and regs over a period of time, and we need to see how our other international regulators are implementing similar type of rules. Back to U.S. person, I think that the definition, I think, somewhat opposed to Wally, I think of the definition for U.S. person is more transactional. What I think about it is what transactions are in scope, and I don't think of it as entity level type of definition. I hear Marcus, and it's a correct concern that, well, but how about the risk everywhere, and what does that mean? Well, I think that to take that a step further, the risk of an institution isn't just derivatives. The risk of an institution is the lending business, it's the deposit-taking business, it's all the other businesses that, for Rabobank's example, that an international bank will engage in. So you can't just say, well, I need to regulate all of these derivatives because that's going to make them safe and sound. You need to take a very holistic approach with regards to regulating the risk of an institution. And that's when we talk to the kind of the prudential regulator that will look at all of our risk, including derivatives.
Ethiopis.
think it'd be particularly helpful if people could be specific as to the consequences of not waiting. Heard general statements as to the need to wait in the interest, I guess, of a level playing field. But the question that comes to my mind, what would the specific consequences be of not waiting? One. Two, I wonder whether or not it doesn't make some sense to draw a distinction between conflicting requirements and duplicative requirements. Conflicting requirements put you in the position of not being able to comply with both sets of rules at the same time. Duplicative requirements are of a different nature, and they may have a cost, and they may have varying costs depending on the nature of the duplication. But I think it'd be useful, and I'd like to hear whether or not it is your view that there is a difference between those two, and whether or not duplicative requirements are actually of much lesser concern than conflicting requirements.
I know we have a few questions out there, and your names have been up for a while. Dennis?
I think it's inarguable, the point that, the strictly legal point that Ananda makes. But I really do agree with the general sentiment that, I mean, what is going to be the alternative? Is we've heard repeatedly, and it's clearly true, that the commissions are working aggressively with foreign regulators to try to get these things to be as consistent with it as possible. The statute is explicit too about the ability to rely on comparable regulation, which this agency has done for a generation. So inevitably, and this is the timing issue, there is going to be a time when there's going to be, in all likelihood, some meaningful comparable regulation. So what are the, I don't know if I wish I had an exact answer for Ananda's question, because I understand the point that he has the statute, but I do think that there's room within the statute to, and we all know, because we've had separate talks previously about particular problems, for example, when a non-U.S. entity has become designated as a clearing organization. And the provision in the statute that if you're going to clear, you've got to be a registered FCM, and it goes to the heart of the whole omnibus concept that's worked so efficiently in the Part 30 regime. But the alternative to not waiting is having firms comply and do whatever structural organizational alterations are necessary to meet the American requirements, and then in a matter of time having to either change them or having to think about the opportunity of changing them. And that's an expensive process. And I guess I wonder if we can't think of a way in which, it's like this definition of U.S. person. To me, the most important thing might be to, whatever the definition is there a way to pick out the elements of regulation that are really at the goal of the statute and at the goal of the G20 undertaking, and come up with a way that, even in a developing way, that through information sharing, through reporting, that while this process is ongoing in these other jurisdictions, the American regulators could reach an appropriate level of satisfaction that they have an idea of what's going on, that the thrust of Dodd-Frank is not being evaded. I mean, this is all very, I know, amorphous sounding stuff, but the timing issue is really a critical one. And maybe if we just thought in terms of the different pieces of the regime that Dodd-Frank contemplates and figure out a different way to reach a level of satisfaction, we could maybe find a way to bridge this timing gap.
All right, David, why don't you take the next comment, and then we'll go to Brian.
Still a fair amount of my thunder, actually. But I think, one, I think you actually have a fair amount of flexibility. You are going to be first. You're going to regulate U.S. markets, and that will happen well before Europe and some of the other countries are finished. But you can be cautious about how you define the extraterritorial scope, because you do have to make a finding that what you're looking at has a direct and significant effect in the United States. And I think if you look at some of the other legal areas where that language has been used, particularly around antitrust, it is actually fairly narrowly construed. So I think you have the flexibility to do what you need to do for your core markets in the United States, to tread carefully extraterritorially. For a number of the firms around the table who are large global firms, we have a very complicated implementation job ahead of us, knowing what we have to implement, to whom and to what transactions your rules apply, is absolutely critical for us. And I think you have the flexibility to define a reasonable scope and to work closely with the regulators in other countries as they develop their rules, as the statute contemplates. And I agree with Ethiopius. Yes, there are conflicts and they're duplicative. We have, at the simplest level, you can't clear the same trade in two different places. Duplicative trade reporting, as an example of a duplication, will be expensive. I think it will probably degrade the quality of information that's available to you as regulators if we have to report the same trade to two different transaction repositories.
Sorry, let's actually take some more and try to clear through this issue. Suparna?
To answer your question on what may be an impact if we don't wait for the harmonization, we have a concern that if we are unable to achieve a high degree of harmonization, both in the rules themselves as well as in timing, then the deep and liquid derivative markets that we currently have, they will get fragmented, and that's going to impact competitive pricing that clients receive today. And it's important for us that the U.S. Remains a competitive trading jurisdiction. There are many investment dollars that must remain in the U.S., and we don't want them to be disadvantaged because we were the first to put forward the rules, and they just may overall impact the way we invest. The other question related with U.S. person, I think we would all, greatly benefit from clarity within that definition. Because if we were to take a case just as an example, if we were to trade, a foreign domiciled account with a foreign branch or institution, but it's managed by a U.S. manager or it's delegated, sub-delegation to a U.S. manager, then what preview would that fall under? So that definition would really help us to, define how our business model needs to change to accommodate all the rules with the various differences.
Thank you. Tom?
So I guess one other example, Ethiopius, in particular, is since we're focused on competitiveness of U.S. firms, one concern is whether there's a first mover's disadvantage, in fact, which is that, while we're completely supportive of going live in your time frame with U.S. clients, whoever defined, one concern from a U.S. dealer perspective is, since it's very easy for clients to just, outside the U.S., to just go to somebody else that's not a U.S. person or the sub of a U.S. person. Once you have this gap period between when the U.S. goes live and the rest of the world goes live, creates a period in which business, client relationships, liquidity, whatever it may be, flows somewhere else. And then ultimately, when the rest of the world harmonizes with the U.S. approach, the question is, can you get it back? And then what's happened in that interim period? It's highly competitive, and this isn't about dealers being able to tell clients what to do. This is about clients telling us what they're going to do. So, that I think is a real point. And to your point about, obviously, duplicative is not as bad as inconsistent. The question is the costs. The industry's got a big lift to get clearing and execution, trade reporting up and running, and obviously that's primary importance. And any costs that slow that down, it's just from a policy perspective, if you can avoid that, obviously that would be a good thing, to be as harmonized and internationally consistent as possible and take advantage of one method or type of reporting that works for everybody.
I think Wally and then Brian. Okay.
So much to talk about, so little time. First, the whole issue of standards and clarity. I suppose if I was sitting up there, I would be thinking in terms of looking at the statutory things. And by the way, you may disagree with what I said about the standards. I was reading from the statute. And what I would do is look at using examples. In other words, I wouldn't try to tie down what is a U.S. entity, non-U.S. entity, and when you have standards that you can deal with in terms of what kind of business it is, what kind of activities they are. But certainly examples would be helpful to give people, pick a number, 99% of the certainty that they need, and the 1% that's on the margin may or may not be coverable, but on the other hand, that might be just the one you need to deal with. Second issue that I really think we should drop back and think about is all these firms have and I did it myself, that's what I did for a living for a while, participated in the derivatives market. Derivatives are ephemeral. They defy the notion of territoriality. They defy a lot of things. They defy understanding. And I really think we have to recognize that we can't sort of wallow around in the who goes first thing and end up in what is in effect a race to the bottom, or what would move this whole thing towards the derivatives markets being in an extra legal environment at the end of the day, as everybody waits for what's going to go on. The fact is, I think that the duplicative issue is important. I was in a briefing of Senate staff on Friday where we were talking more in terms of overlap rather than duplicative, but it's the same point. I think that has to be embraced because it's going to occur. And I think one thing that industry needs to do is recognize that the regulators are not foolish. They're not here or in Europe or anywhere else. They're actually going to deal with overlapping regulation, and overlapping regulation is inevitable in such an ephemeral market. And I think that's just an important thing to think through. And again, if things that require contrary behaviors are problematic, but overlap, duplication is inevitable in a marketplace like this. Last, I'll get everybody's hair. The whole issue of entity versus transactional. I know the industry wants that. I can't figure out what the justification of it is. The statute gives a pathway to deal with these issues, and in my way of thinking, there are transactions that are jurisdictional that are covered, and then your behavior with respect to those transactions might constitute you a swap dealer, whether you are, whether your country of origin is Pakistan or the United States. You might become a major swap participant. But the question is whether the transactions are jurisdictional and the activity is jurisdictional. That's in the statute. So I don't see some giant divide which would say certain kinds of attributes of entities categorically eliminate them from jurisdiction under this statute. Maybe I'm missing something, but the argument's made that way. I've read every law firm paper I can find in terms of comment. I can't find the justification for it, and maybe folks could enlighten us all. So, thank you.
Thank you. I wanted to drill back down on something that Luke and Wally and Marcus talked about a bit earlier, which is about subs, foreign subs, and both where there's just ownership and then there's a guarantee. And I guess for Wally and Marcus, let's take the situation of a dealer in London that's owned by a U.S. entity. Just ownership, no guarantee. What's the concern that I think I heard you suggest that should be of concern to U.S. regulators. What's the concern there? And then on the guarantee side, why, for example, is not the MSP category? So if you have a U.S.-based parent guaranteeing a foreign sub, you would aggregate up I think under our proposal, to the parent company for purposes of MSP, but you wouldn't necessarily apply dealer regulation to the foreign entity. And I guess Luke, asking the exact opposite question, so I sound fair and balanced, why shouldn't guarantee? So if a U.S. Parent decides to guarantee the activities of a foreign-based dealer, why shouldn't that be within the purview of U.S. regulators? Or I guess asked a different way, why isn't that a pathway to avoid Dodd-Frank? And I open that up to the rest of you as well.
Well, I do think that in 2008, we saw a number of off-balance sheet entities that didn't have an explicit guarantee but had an implicit guarantee for reputational reasons of the parent company. And that was an issue. And it's also, I'm going to confess to not being a lawyer now, but it's, as I understand, it's also an issue in the laws of various countries, whether you can sort of pierce the corporate veil and get up to the parent even without an explicit guarantee. And what I wasn't seeing in the industry comments is a specific explanation of why that is not going to happen. And I would think that would be important. And just, okay, so I'll leave it there.
I think I'd like to go, everything I agree with there in terms of guarantee. I mean, my familiarity with doing swaps is, if the swap is with an entity which is guaranteed, it's the parent that you're dealing with. But further, I think that the key issues are, what is the business, what are the activities? And so there's more than just guarantee. There's like, is it a composite book? Is it a combined book that they're looking at? Are they sharing systems? Are they sharing management? Is the decision-making and the strategy in common? I think those are very pertinent issues, and I think that, again, to me, Dodd-Frank gives you the sort of the thrust of what you're getting to. It's not just financial guarantee. Is it all part of the same business? Is the activity the same? Because it's the effect on the markets that's important.
So are you suggesting that it's not a guarantee alone or ownership alone is not enough? It's a both and. It needs to be something more like common systems.
No, what I'm saying is beyond guarantee, right? There are other issues. It's a matrix, either or. It's a matrix of things, right? So.
Bob, did you have you've had your name up for a while. Did you have a comment on Brian's question or something previous?
Nothing on Brian's question. I'd like to talk a little bit about
let's hold and try to get this one question and stay with the theme. Does anybody on this side have a, David,
I'll put this in Ethiopis' conflicts category, and I'll take Shell as an example. If Shell has a subsidiary in Germany and I want to trade derivatives with it today, I would do that through a German organized entity or another EU passported entity, because derivatives are a regulated activity in Europe. Neither of those entities are likely to be, would otherwise likely to be registered as swap dealers. So it's a reasonable possibility that Shell Trading Germany would not find a U.S. firm that could be a counterparty. Right. The way we are all organized today, we are generally going to have an EU-facing entity. Now we're optimistic that in the MiFID revisions there will be a greater accommodation for cross-border activities into Europe, but I'm not sure that reaching out and with this broader scope is going to help that debate within Europe. So there's just a plain conflict issue. We may not be able to deal with Shell's non-U.S. subsidiaries.
Luke, did you?
Sure. Brian, with respect to your question, I'll answer it from a policy perspective, putting the end user hat on, and maybe we'll use margin as the sort of window through which to examine this question. But end users would be concerned with the potential for a diminishment of essentially good pricing or an a degradation in transparency that might occur from the scenario which you describe. And to put forth an example, if we're a foreign subsidiary of a U.S. company operating in Europe, if we have the opportunity, the ability to trade with, say, Barclays and BNP Paribas and other foreign banks, and the ability to trade with the foreign branch of a U.S. bank, if the requirements on the foreign branch of the U.S. bank are more severe than the requirements on the foreign bank, it will certainly influence with whom we determine with whom we'll transact. If those more severe requirements cause us to avoid interacting with the foreign branch of the U.S. bank, it could have the unfortunate consequences of increasing the pricing, or at least the competitive dynamics that are available in that particular situation. So I think that's a policy concern that would be there for end users.
On Brian's question, I'm looking at Bill or Bob, or I'm sorry, Bob. Bill, did you, Rabobank?
I don't know if it's specific to Brian's question, but it's related to the general themes, and that is, starting with the harmonization, and harmonization is happening, and BIS 3 is happening, and that regulates not just derivatives, but it regulates the whole entity of a banking organization. It includes new regulations with regards to liquidity rules and regulations. The global rules are taking place. They're going into effect. In Europe, you have EMIR, and it was mentioned MiFID II, that are going to regulate the derivatives. So this harmonization of these global markets is happening. It's not going to happen at the same time, and it's probably likely going to be staged by different legal jurisdictions. The solution to that not happening at the same time and having them all be the same, from my perspective, isn't to take a global approach and say, well, then I'm just going to regulate everything around the world because that isn't up to my standards and what I want to do. So I think that's the wrong approach to take with regards to concerns around rules and regs within other legal jurisdictions. And the reason why I think that is, and it gets back to the point of if you do have conflicting rules, and by nature, if there's a conflicting rule, then what do I do? Do I not trade? Do I not offer that product? Because if I do, I'm wrong here, but I'm right here. But which one do I care about more? So the whole nature of conflicting rules with regards to derivatives is a big one, and I think that we need to be mindful that there will be conflicts, but will these conflicts that exist in other regulatory regimes be acceptable to U.S. regulators? And my guess is that they will, because the conflicting rules will be specific to those local markets.
I just want to finish Brian's question on foreign subsidiaries and ownership and guarantees. Does anyone have one last comment? Okay.
I would just note that obviously we're moving into a world in which we no longer have unregulated activities, unregulated entities. Everybody is going to be registered as a swap dealer or regulated in the world in those activities. All the holding companies are now regulated and subject to prudential regulation. So, and in particular, all the swap dealing entities are now going to have their own capital requirements. So, it just strikes me the guarantees have ceased to be as relevant from a risk perspective. Counterparties like them because typically the guaranteeing entities are the ones that have the rated debt, which is a proxy for understanding the credit rating of your counterparty, rather than having each entity around the world have a standalone rating. But given the capital requirements and other regulation of all the swap dealers now, it strikes me that the guarantee issue from your perspective is less of an issue than it was before.
Dan, would you like to ask another question?
Sure. Thank you, Jackie. Much of the discussion is we've talked about the various results, what the result of the extraterritorial application should be. How should it apply in this circumstance, or how should it apply in that circumstance, transaction-based, entity-based, whatever. Sitting here from the agency perspective, equally important as the result is how do we get to the result? How are we going to make those determinations in what context? Is this something that would be done through a rulemaking? Should the agency say, okay, here are the various circumstances, and here we're going to apply our rules in these various circumstances? The one issue with that approach is obviously there's a variety of circumstances. I've been through, personally sat in a number of meetings, and there's just a variety of different structures and countries, and we're also talking about global harmonization and waiting on jurisdictions, but there's actually multiple jurisdictions that we end up maybe waiting on, so there's not necessarily a one-size-fits-all answer for the various jurisdictions. Or an alternative approach is in a registration-specific or transaction-specific determinations. Agency has the flexibility to either make determinations by rulemakings or by individual adjudications, and applicants could come to the CFTC and say, here's my bank, and I'm in this country with this type of regulation applicable. I think, these regulations should apply. Dodd-Frank should apply to these transaction requirements, but my home regulation should apply to these other types of requirements. That would be a more individual determination based upon individual registration proceedings. For the agencies, that's a much more resource-intensive determination. There's also much less certainty for market participants as to the ultimate result. But it could be more tailored. On the other hand, a rulemaking approach could either be over-inclusive or under-inclusive. I think in a general approach, it could be some entities could feel, well, my specific situation doesn't particularly apply to how the rule is being developed. So be interested in participants' views on the method by which we should be resolving some of these questions in addition to the result to be achieved.
John.
Thanks, Jackie. Yeah, Dan, in answer to your question, it's a good question. I mean, I think setting it out in a rulemaking is important to give market participants a roadmap and some clarity in terms of how to set up their business and so forth. I think the agencies clearly have the discretion to do that. I think the agencies have the expertise and the expectation to do that. What I would say in terms of general thoughts on the matter is look to what is already in place. Look to what has worked in the past. I think the CFTC's Part 30 framework has worked. I think that it held up very well during the financial crisis and should be looked to as a guide. I understand the differences between the swaps market and the futures markets, but I also think that the swaps markets are clearly moving towards the futures markets in terms of centralization of execution and clearing, which would probably make a little more sense in terms of a Part 30 framework, and not to discount the SEC's 15A6 framework either. Also, I think takes into account to a certain extent comparability of foreign regulation. The other point I just wanted to throw in there is in terms of the language relating to a significant indirect impact. I have to confess I haven't read the legislative intent on that, but I wonder whether that may be more related to a catch-all type provision for enforcement purposes, as opposed to language which is really set out to establish things like registration and reporting requirements. Obviously, the agencies have to have broad enforcement authority, but I'm not sure that language is necessarily put in the statute in terms of setting up the initial regulatory structure. Thanks.
Bill.
Dan, I think I would certainly agree with you. And I think most participants in the swap market would agree that having a clear guidelines as to how the markets are going to work is preferable than having bilateral discussions. Well, this is how I am, and this is how I think I should do it. And I think this discussion we're having right now is very direct towards that, and that's defining what's in scope. And if we define what's in scope, clearly define what's in scope, then the organizational aspects and the differences between entities can be resolved. And again, defining what's in scope is the U.S. person. I think the Reg S definition is one that has been cited as a good reference point to use with regards to the definition of a U.S. person. I'm not a lawyer, but it seems reasonable and logic to kind of base the definition on the scope of the transactions, or would be a Reg S determination. Similar to John, that direct and significant is something that's in addition to this, and I would think that it does give the regulators and also the market participants we should determine when we see something direct and significant, and that I think would be more like a manipulative or fraudulent type activity. So a very kind of very high hurdle to overcome with regards to direct and significant. So I think that having the definitions of a U.S. person clearly defined is going to resolve, I think, a lot of the issues with regards to the differences amongst entities.
Suparna?
I second that, more harmonization and clarity in the rules themselves, perhaps maybe, phased in on the effectiveness of these rules is a better approach. If we were to consider, the second alternative that was presented, which is highly customized, for an end user that has many counterparties that they deal with, not only would we have to understand their their customized structure, then we would have to overlay our own account structure on top of that, which could become a very complex exercise.
Wally?
I think that given the nature of the swaps market and derivatives market and its breadth and its the ephemeral stuff that I was talking about earlier, it seems to me that the right approach is to again, embrace overlap and duplicative so long as conflict is taken into consideration, which means that I think the right approach is to not make some sort of cosmic high-level definitional construct, but rather deal with the standards and say these activities aren't included. And the reason I'm saying that is, while overlap is, if properly done internationally, is inevitable and something to be dealt with, gaps would be problematic, because the other part of the swaps market is it's very portable and it's very easy to exploit gaps. So what I would do is go with a broader sort of approach, but with some concrete examples so that to provide people guidance. One more thing real quick. The whole issue of the materials I was reading, I'm sure a lot of folks are familiar with it. It's not an issue of manipulation of the market. It's really the standards for extraterritorial application. And I get most of my learning from Sullivan and Cromwell. They're writing for the industry, so that was what they were thinking. I don't know. I got it from those folks. So I think those issues really do apply. By the way, they're intended to apply to the extraterritorial issue.
I'm going to take one more on this issue, and then we're going to move on, okay? So I know you haven't had a chance to speak, Bob. Go ahead.
Well, first, to Dan's point, you can't do it transaction by transaction or entity by entity. I think you have to set up categories of different types of transactions. And I think one of the things you need to look at when you set up those categories is the location of the underlying product. Right? Commodities are a little bit different than financial products that we've heard a lot about this morning. Commodities are tangible, they're used by real people, and they're used in real places. All right, so I think that you have to take that into account when you think about, what is something that has a direct and significant impact on U.S. commerce. So going to David's example for just a second, if we have a German subsidiary of UBS dealing with a German subsidiary of Shell, and they're trading German fuel oil, I think it's pretty clear that Title VII would not apply. Now, on the other hand, if trade is involving a U.S. bank, say a German branch of a U.S. bank, then perhaps that's a little bit closer call. But I would argue that if we're talking about the underlying commodity being German fuel oil, that should not be a jurisdictional transaction.
Interesting. I actually want to. I want to move on. I'm sorry. We've got. I know a lot of people want to keep going on this one, but Ananda.
One of the considerations is the desire to treat people in the same circumstance the same. What do I mean by that? I'm going to pick two banks here, right? Goldman Sachs and UBS. You're headquartered in Switzerland. You're headquartered in New York, right? So let's say the commission were to say, okay, you know what, Goldman Sachs, you need to register the swap deal. And let's say both of you do activities that bring you within the definition of a swap dealer. And the two commissions were to say, Goldman Sachs, you have to register with us and with the SEC. UBS, you don't have to because you're subject to regulation in Europe. So question, is that fair? Because I think that's one of the things that we have to grapple with, which is how do you treat people? Now, you choose to do business in a particular way, right? Now, I guess UBS could set up shop in the United States and do it that way. That's up to you. But I think that's a critical, from my perspective, a critical element of whatever it is commissions have to do, which is treat people the same.
Why don't we go Tom and then Dennis? Is that okay, Tom?
First of all, it's not fair. But, I think what we're saying is that with respect to U.S. people, everybody is going to have to comply with the rules, whether they're based in Switzerland or based in New York or wherever they're based. So that's not in question. The issue is with respect to activities outside the United States that are happening we have global entities with U.S. and non-U.S. clients in them. So how do you treat the non-U.S. activities of these global entities? From our perspective, the prudential regulator's margin rule is very unfair. It's asymmetric. I mean, it applies one set of rules to U.S.-based organizations and a different set of rules to non-U.S.-based organizations. We're not sure why the activities of a non-U.S. bank who has significant U.S. activities don't need to be regulated, but our offshore activities do. So, we think that the rules should be fair. We think everyone's going to have to comply with the U.S. rules. And with respect to the non-U.S. rules, we think there should be an even playing field between U.S.-based firms and non-U.S.-based firms with respect to their non-U.S. activity.
Dennis? Sorry, Dennis and then David.
Yeah, I think that's pretty clear. And I think it's important to have brought that point out because if you're dealing with an American resident counterparty, then it's pretty difficult to get yourself out of American regulation. Now, there may be some de minimis exceptions to that. And by de minimis, I don't mean the de minimis that's been proposed, but something. But still, that's really it. And the rest of it, really, it seems to me, ought to be dealt with through some information sharing and from an aggressive use of enforcement authority on things that, like, for example, market manipulation. And I do agree with Wally and a little less with John about what this language is intended in the statute. I think it is a regulatory provision. It's not. I think the Enforcement Division would consider that to be a pretty constrained reach on its ability to go, and certainly historically it's been much more aggressive than that in terms of manipulating a market. Personally, I don't know the difference between German oil and American oil, but I appreciate the attempt to distinguish them, but I understand from a manipulation, a market price standpoint, and from the enforcement ability, that's a separate category. But my point is that is there, and that is available, has been, will continue to be. So if you're going to regulate anybody who's dealing with an American resident counterparty, which is the bulk of really what this ought to be all about, then I think the rest of it, as difficult as it is, to me, that's why I keep coming back to the timing issue. I mean, the talk about duplicative and conflicting, to me, would almost be the good news at this point. because that would mean that there's something out there that you can compare it to, and we can make some intelligent decisions about how to apply it. But we're not even there yet, which is Ananda's point. But I think that, as I said before, if there are ways to parcel out the elements of what you care about, I mean, I think when you consider this is a great success for what the G20 wanted. Everybody in the universe agrees with this fundamental, or at least generally. All regulators want to force everything to clear. All regulators want more transparency, and that's where everybody is going. So, trying to accommodate a harmonized way, and harmony is impossible, really, but a reliance way, a mutual reliance way of dealing with that when everybody is sort of generally moving in the same direction, I think ought to be an achievable goal.
David?
Yeah, I think, responding more to Tom's point, I think for internationally active financial institutions, we think there should be a level playing field, so that if Goldman Sachs is acting through its UK branch or a UK subsidiary, the same rules ought to apply. We care about it. Some foreign banks active in the United States may well end up registering their main bank as a swaps dealer, right? In which case, we would expect, if our London branch is dealing with a French counterparty or a German counterparty, that it would generally not have to follow U.S. rules. But if it's dealing with a U.S. counterparty, absolutely, every requirement applicable to a swap dealer must be complied with. Without that, I think a number of institutions will run into serious difficulties in how they structure their operations, certainly in the near term, and constraints on their operations in the longer term.
Let's take one more, then Robert. So, Wally?
Some great comments, Dennis, especially. That was a very wise discussion of things. Tom was talking about the fairness and fell into activities, and then Bob was talking about physical commodities and how they're different. And I sort of put those things together. It's kind of an interesting thing. It really goes to the issue that makes this so hard. It makes it so that broad rules perhaps are best with carve-outs. And right, petroleum products may be different in Europe, but on the other hand, commodity index funds shifted famously between West Texas Intermediate and Brent in favor of Brent in February, which after that, for whatever reasons, possibly for that reason itself, there was this huge disparity between Brent and West Texas Intermediate, and prices changed on West Texas Intermediate oil in the United States. So my point being, activities and physical and not in our country, but a huge effect back into this market. So I think that really speaks to the question of how extraterritoriality has to be flexible enough to deal with the kinds of effects that come back into the market, and because of the way swaps are structured and the marketplace has grown up, I think flexibility is really called for, and we would really endorse that as a concept, and then carve-outs for activities that do seem to be non-jurisdictional.
We've spent a lot of time talking about who is and who is not, who should be and who should not be a U.S. person, and it feels a little bit like it's an all or nothing thing that we haven't been very nuanced about whether are you in for all requirements. So I wanted to ask whether that's intentional. Do you believe that if you're in for everything? We have a number of requirements that are in play here. One is the entity registration and the entity conduct rules. Another is the trade reporting rules. We have mandatory trading requirements. We have mandatory clearing requirements. Should the way we think about who is subject to those rules differ based on between those rules, or are you thinking that once you're in the regime, you're in for all purposes?
Marcus?
Oh, well, I think this goes back to something that I think John was saying earlier when he was talking about the direct and significant test possibly not applying to certain kinds of registration or structure and reporting, that it was more limited. And I feel also that I disagree with what he was saying in that case. I think the direct and significant test goes to the overall goals of the statute. And I think what you want to do is you want to trace back the various requirements to the key underlying goals of the statute, which involve transparency and systemic stability. So I don't think anybody really cares if a company is reporting some information about its swap on page 4 on the German form when it would be page 2 on the U.S. form. But you care a lot about whether it's reporting all the necessary information on that form, because that goes to the transparency issue. And this, to me, is why it's so potentially worrisome that people are talking about exempting from margin requirements, because that goes directly, margining uncleared derivatives goes very directly to the stability requirement. And because I just want to also mention a few things that people have been saying on this direct and significant connection, that there seems to be sort of an attempt to inflate how important that connection has to be. We heard the word dramatic used before. I think that was David. That's not in the statute. And the statute itself says a direct and significant connection with activities in or effect on. So that effect on is also important to think about. And one last point, something Suparna said before, and I think often gets said in connection with this discussion, is that the argument is made that we need to limit our extraterritorial reach in order to preserve investment dollars that we want to remain in the U.S., in order to help the U.S. economy by making U.S. companies more competitive. Well, if that's the case, then that's a connection back to the U.S. economy. I mean, it almost seems to be the case that people argue that we have to restrict the extraterritoriality on the one hand because you want to help U.S. competitiveness, which will help the U.S. economy because those profits will flow back to the U.S. But on the other hand, if we limit it, those risks will not affect the U.S. economy because the losses will not flow back to the U.S. That we're going to sort of have our cake and eat it too. And that seems to me to be a contradiction. And if you want to make the argument that that the profits are going to come back to the U.S. economy, you should have to be very specific about how those risks won't come back to the U.S. economy as well. So,
Bill.
It's a good question, and I think the answer has to be year end. And what does that mean? I think with regards to that particular transaction, all the transactional requirements with that, which is reporting, clearing, etc. Then it gets a little bit more difficult when you think of some other elements within the rules and regs, which margin. I think it's possible to be in on margin. It gets even more complex when we think about capital. So that particular transaction, I need to hold this amount of capital because this is where this jurisdictional rule applies for this particular transaction. That I think gets more problematic because the whole concept of netting and the kind of the global transactions that I have with a counterparty. So, largely you have to be in. I do think that it does get back to a question that I think we'll discuss hopefully sometime this morning is on the affiliate transactions, because then I think about, well, you're in, but then I think about how I manage my book and market risk, and being able to transact with affiliates is important to have those out in order to be in with regards to transactions with U.S. clients.
Dennis.
Sorry. I want to make one point about the statutory language. Have a direct and significant connection with activities in or effect on commerce of the United States. It says the commerce of the United States. It doesn't say commerce in the United States. commerce of the United States is a pretty profound thing, it seems to me. You can affect commerce by picking up the phone from someplace and having a baseball mitt delivered to where you are. But to affect the commerce of the United States in a direct and significant way is a pretty high bar, I would think.
Suparna.
I think it's also important to understand what touch points, in the transaction or the entities involved would bring you into the preview of Dodd-Frank. I mean, there are some less obvious than just the counterparty themselves or the client, such as like if you have some operational efficiencies in your process where you may handle all your confirms within the U.S., or your collateral management may be, U.S.-based or U.S. dollar denominated, things like that. Would that include you if you are dealing with a foreign entity from a trading perspective, and the client is also, based domiciled outside the U.S.?
Thank you. Ethiopius, and then I'm going to jump in.
Thanks, Jackie. I wanted to get back to something Dennis said earlier, and I think he's right in that it was a pretty significant achievement to get the G20 jurisdictions to agree on trading, trade reporting, clearing, and dealer regulation. Of course, they agreed at a relatively high level, and the devil will be in the details. And until we've seen how various jurisdictions give effect to those principles, it's hard to say what the level of comparability really will be. And depending on the level of comparability, we may be able to get to reliance or not. But as a complement to that, I wanted to probe something David Kelly said earlier, I think he said, in that you were saying the timing issue, which is of concern here as I hear it, is of lesser consequence if the scoping is right, or the scoping of our rules. Or are you saying that even if we scope them correctly, the timing remains of consequence and of concern in light of competitive concerns you may have or competitive issues that arise?
It remains a concern. But I think that if you, with a narrower extraterritorial scope, at least initially, for your rules, it makes our implementation jobs and our compliance programs easier to develop. If we know what we're doing, there is clearly still potential for conflicts of regulation between the United States and other jurisdictions. We have some of that today. This will surely give us 100 new problems to solve. And I'm sure we'll be working with you to try to do that. But I think as a practical matter, your implementation time schedule is probably not going to be the same as certainly the slower people in the rest of the world.
John?
Thanks. In answer to Ethiopia's question, I think timing is less of a concern if you do get the scope right. In particular, thinking about the potential issue of retaliation. I think if we are overreaching, over-inclusive, we invite that from European and Asian regulators. And just to throw out an example, requiring a non-U.S. clearinghouse to register with the agency as a DCO, for example, or to require every clearing member of a non-U.S. clearinghouse to register as an FCM. We need to think very hard about that, I think, and I understand there's issues with that on the regulatory side, absolutely, that need to be worked out. But I think if we get the scope right, I think timing is less of an issue.
Tom?
Just on your point, Ethiopius, I think I generally agree with your statement. I think with respect to, let's assume the rules are just applying to U.S. people, for example, I think within that scope, we still have to be focused on, which you guys obviously been doing a lot of, phase in and sequencing. So how we sequence the implementation of the rules and how they're phased in will have a big impact on how how much we can get done and how quickly. Because, some things, arguably go before others in the implementation timeline of things. But as a general matter, I agree with your scoping point.
Okay, last comment here, Wally.
Yeah, just quickly. Again, U.S. persons, that is the task ahead of us. In terms of scope, just keeping in mind that the U.S. regulatory scheme is an articulation of what the legal and business community, how the border has been drawn between unacceptably risky behavior and less risky behavior, so that the competition issue is by definition talking about engaging in riskier behavior, then the culture has sort of suggested is the proper behavior to engage in. Now, I know it's not as simple as that, but we should keep in mind that, and I understand folks just want to do business and make money, I got it, but we should keep in mind in saying, that's problematic to me because I can't compete in that kind of activity, is that is specifically the kind of activity that the culture has said is too risky to do.
When I opened this panel, I talked about this. We would address clearing, reporting, and trading, those issues that apply to all persons. And we've kind of danced around whether there are true conflicts or whether it's mainly overlap that we see developing, and understanding that the rest of the world doesn't have a solidified position on anything yet, really. But we have seen Europe emerge with proposals, and Japan. I want to ask the panelists if they see any true conflicts emerging regarding clearing, trading, reporting. Are there real conflicts, or are what we're seeing, what might emerge are really overlapping and duplicative, or do we see conflicts? Luke?
One significant conflict would result if the scope of the end user exemption in one regulatory jurisdiction is different from that in another. And whereas the scope is firmly set here in the U.S., it remains fluid abroad. One area where there is currently disharmony, or is trending to be current disharmony, is with respect to the real estate sector in terms of how Dodd-Frank treats that sector and how EMIR treats that sector in European proposals. Real estate is fundamentally non-financial in nature, and real estate companies use derivatives to hedge commercial risks, but it can often be owned by entities that are financial in nature. Dodd-Frank took a nuanced approach in assessing whether or not real estate entities were financial or non-financial, used a two-pronged test considering both the legal structure and the underlying business activity. EMIR is currently drafted such that it focuses exclusively on legal structure, and consequently many real estate companies in Europe and American companies operating in Europe could be subject to a different availability with respect to the end user exemption. And so we would encourage, to the extent possible, that U.S. authorities work with their foreign counterparts to ensure that for the benefit of competitiveness, any disharmonies between the U.S. and foreign approaches are resolved with respect to the end user exemption.
Sticking on sort of true conflicts, Suparna and then Tom.
On the clearing front, there is a difference emerging currently on the collateral protection for clients in the U.S. We have the omnibus structure, and the CFTC has put forward an alternative approach. In Europe, you see more of a segregated model. So that's one of the areas where there is a difference. In related with reporting, I'm not sure if this would be conflict or duplicative, but if a U.S. Entity that's account that's a non-MSP were to trade with a foreign swap dealer, then the reporting requirements are falling upon the U.S. Domiciled entity, which could be a little bit problematic because it's just a small set of transactions. So we would like to see maybe the reporting to to reside with the swap dealer, even if it is a foreign registered swap dealer.
I mean, I would just note there's a lot of uncertainty still with the European rules, for example, so people are projecting out what they perceive to be what will be real conflicts. So, for example, if there's a European margin rule that has a similar European-centric approach to the U.S. approach on collecting dollar margin or treasuries, and the Europeans say you have to collect collateral denominated in euros, for example, that would be a clear conflict if you're a U.S. registered swap dealer. And also, for a European client trading with a European entity that's a registered swap dealer, if they trade a 5-year interest rate swap that's mandatorily cleared here, and then Europe also requires clearing of that same transaction, I think people are just wondering how that's going to work, right?
Bill?
Yeah, I kind of agree with the concept of what Luke mentioned is it's important to identify scope, and then once we can identify scope, then we get conflict. We can understand what the conflicts are. I think that the conflicts that were mentioned are going to be the conflicts within the regulations that will develop. I'd also want us to put ourselves in the shoes of the European regulators, and they're thinking of this as well. And if they take a broad interpretation of scope that is beyond their borders, let's call it, we're going to run into similar conflicting rules and regs with regards to transactions here with U.S. Customers. So, scope is an important one, and I think if we can clearly define the scope, I think we can eliminate a lot of the conflicts that will that may exist.
Bob?
In terms of conflicts, I also think requirements for exchange trading are an area where we could have some discontinuities. The role of brokers, bringing counterparties together. And then I just point out that the definition of hedge and differences in how hedging might be defined would have major implications both in the area of position limits and also the application of the end user exemption.
Thank you, Brian. Sorry, Dennis. Yep.
I just wanted to make the observation that in the call for clarity, which is hard to argue with, I guess the concern would be that that's great as long as you get the clarity you want. Because you may get a lot of clarity, and I don't know where that takes me in that observation, but it does. And I'm just going through the list of differences that have already been identified that people have pointed to. I mean, you get into the weeds on this stuff. This is pretty serious stuff, pretty serious differences. It's how you're going to reach harmony on these kinds of things. I mean, I don't think no one envies the job that you have. I certainly don't. But I think that's really drives towards a more conceptual approach and a communicative way of dealing with this with other regulators. I don't think that maybe that gets you nowhere because people are definitely going to have to make a decision on where they're going to clear that 5-year interest rate swap. And so that's something like that. Somebody's going to have to decide what you do because you can't violate one law by complying with the other one. I don't know what you're going to do about that other than have more meetings with your colleagues. But I guess I'll stop there.
Thank you.
I wanted to come back to U.S. person, but focus on it from the perspective of the intermediary being the U.S. person. So, for example, UBS's New York desk or Goldman's New York operations intermediating a transaction between, for example, its affiliates or its home bank and a Canadian counterparty. So the two counterparties to the transaction are not U.S., but the desk is the intermediary is a U.S. person. First, does that actually happen in the real world right now? And second, if it does, how should these three requirements, the reporting, the trading requirements, and the clearing requirement apply when the only U.S. person is the intermediary, not a counterparty to the transaction?
I'm sorry. Superintendent, did you have a comment?
Yeah, Brian, I just wanted to add to that the intermediary could also be the asset manager. So, just to keep that in mind.
That's actually, you mean where the manager is U.S. based, but the account is actually a foreign-owned account.
Yes.
So, yeah, it's actually a good.
Exactly.
Yeah.
And also the counterparty that you trade with is a foreign
counterparty.
Right.
So,
David?
and the answer is yes, it's real. It probably happens every day at least at Tom's firm and mine. And so BlackRock in New York calls my trading desk in Stamford and trades a 10-year interest rate swap for a Brazilian counterparty, for a Brazilian client whose money is managed by BlackRock.
And you're setting it up with somebody overseas as well, with your home bank.
Yeah,
for
UBS
example.
AG London branch faces big Brazil company.
So how should the rules apply? You answered the easy question, not the hard one.
I'll start fairly simply, and I don't know the answers to all of these questions. I just know that I don't want the answer. I don't want there to be a different answer to the question, or I don't want to be required to clear the trade in two places. I suspect, given the involvement of a European entity and a U.S. entity in the short run, we will probably have duplicative transaction reporting because both of you will want transaction reports. I'd like that. I'd like, hopefully, between you and Europe and the rest of the world, you'll get over that at some point and we can report it once. At the very least, it would be nice to be able to report one set of information and not have to report 3 or 4 different sets. In terms of clearing, not sure if it's a clearable product. I suspect BlackRock will want to clear it. And if it can clear in the U.S. and Europe, I think actually we'd prefer that the choice be directed by the client. Right? I think it will ultimately be end user who will be, at least on the institutional side, who will be driving where trades get cleared.
I know Anand is anxious.
So if we took the approach that the requirements apply to the people responsible as opposed to people who may have, I'll pick Superna's company, for example, right? I suspect right now that BlackRock is not the counterparty swaps, right? It's your client is, because the client is financially responsible, right? So in the example we just gave, let's say we said the large Brazilian company is the counterparty and UBS AG is the counterparty. Let's assume UBS AG registers, right? Okay, because a branch is not a legal person, so it's you go back and yeah. Now okay, we can talk about that. Right now, nobody's been able to convince me that a branch is a legal person.
Next panel. Next panel.
Okay. So then the question is the Brazilian company subject to Dodd-Frank, right? That's the question, right? As opposed to, maybe I'm wrong. Maybe people are saying it should be BlackRock that's, because BlackRock is exercising certain amount of, discretion, whatever it is, that they have to register. I don't know. I know what your answer is, but I want to know what other people's answer is.
Like, Luke?
I'll just add to the complexity of this question by noting that the issue also arises with end users who have centralized treasury groups that execute for the ultimate benefit of affiliates. And we would certainly welcome clarity on how inter-affiliate transactions might be handled. In this case, end users typically view the intercompany, the inter-affiliate transactions that they execute to transfer as mechanisms that simply transfer risk within a corporate group. And so would hope for or look for any requirements that apply, not apply to those inter-affiliate transactions, except perhaps for reporting, because those don't have a material bearing on systemic risk concerns.
Tom?
So obviously it's a hard question. I mean, one obvious answer may be that the Brazilian client's not a U.S. person, and the rules, shouldn't apply to them. But obviously, one of the concerns I have is a lot of the focus on international issues is focused on Europe, and there's a big world of clients out there in Asia and South and Latin America and North in Canada that where clearly the regulatory regimes are even farther behind where Europe is. And so how do we make sure the regulatory issues are dealt with, but don't really wholesale those markets to other people away from U.S. firms, because the Brazilian client will just say, well, I'm not going to follow the U.S. margin rules when I can trade with an Asian bank and not have to. So, I mean, I think this issue of where the globe is at different places is actually a big issue because we're so focused on Europe and versus the United States. But I also think another issue we see quite frequently is that the risk is moved into the United States because a client outside the United States wants to trade an S&P 500 swap. And so a non-U.S. entity may book the trade, but the risk may get moved internally to a U.S. swap dealer, which gets to the whole question of whether intercompany trading is subject to registration, margin, CEF, clearing, all those kind of things, which is a big issue because if you can't move the risk to the place where you have the expertise, that makes everything more expensive and makes you less competitive as well.
Wally?
I think we've just seen a discussion that suggests that all of these things should be within the jurisdiction of Dodd-Frank, but might be treated differently rather than making some giant decision in scope, saying that categorically the scope of Dodd-Frank is limited more narrowly than what's completely suggested by the statute itself. And so a transaction that's really between the Brazilian and Swiss entities might have a different result, even though it comes through the United States. It's clear the activity inside the United States, part of that activity is. That might have a different result than an activity where an end user or anyone else actually, through affiliate swaps, puts the risk in a combined comprehensive book and it's as part of one business, notwithstanding the fact that maybe it originated with a swap by a subsidiary. But it's really part of the whole business. It's, say it's in the same book, it's guaranteed by the parent, all that. That's really, that's a duck. So, I think the gist of it all is that probably all of these are within the scope of Dodd-Frank, but might have different outcomes from a regulatory standpoint because of policy considerations.
Can you just drill down, or Tom or Wally? I mean, if the rules do apply to the New York desk, why isn't the result Goldman and UBS move to Toronto, the desk that does that activity, so that they can intermediate the UBS AG London branch and the Brazilian account, or BlackRock moves from Connecticut or wherever you're located up to Toronto, so that you don't have this type of transaction subject to Dodd-Frank?
Yeah, let me just say, okay, I understand what you're saying. And if the scoping is done so that you allow people to use subsidiaries to move a subsidiary up to Toronto, you make it really easy for them to do so. However, I don't know how you get around the fact that you've got a concept of territoriality, whether it's the United States, Canada, Europe, or Japan, and you're trying to regulate a business which is by definition defies the concept of territoriality. So, if we give in to that, we end up with mathematically, I have no mathematics, I'm a lawyer for crying out loud, but I think mathematically you end up with virtual lawlessness. I think you eventually get to the lowest denominator, and so soon you're worried about people going off to I don't want to offend anybody, some country in the Pacific, a tiny island in the Pacific. So I think yes, you're right, but that calls for a broader scoping definition with pragmatic rules, so that you don't make it easy for people to move across the border to Toronto or to Pago Pago. Right.
I actually think, Tom raises an interesting point with regard to the this coordination in terms of timing as between us and some other regions other than Europe. But I think the point and example you raise leads to a question for Suparna, which is that the choice that you would make, or is that the choice that your client would make? In other words, if the choice is between working with Goldman Sachs in New York or dealing with some intermediary in Hong Kong that's unregulated, are there pressures that actually push you towards Goldman Sachs as opposed to, and this is probably an impolitic question, but what is the choice that you'd make in that situation?
I think that you would need to consider where you get competitive pricing, and also overall strong counterparties for your clients. So I think it would depend on who's on the other side. If you have an equally strong counterparty that's in Hong Kong, and you're able to get good liquidity and pricing available there, you're going to see a gravitation of choice moving overseas.
John?
Yeah, I guess, just quickly, I think to take Brian's example, it seems to me that if you have a U.S.-based intermediary and two non-U.S. customers on either side, that U.S.-based intermediary is going to have some registration requirement, be it a FCM or a BD, in which case it itself should be subject to all of the relevant Dodd-Frank rules. The transactions on either side, I would think, would be also subject to the Dodd-Frank rules as well. I'm not sure how you can get around that or would want to get around that, frankly. And to Ethiopis's point, I think it's a good point, which is we tend to be thinking about regulation in a negative connotation for business, but having worked with many of our customers, I know that they do look that being able to conduct business in a robust regulatory framework is generally considered a pretty good thing.
Actually, that sounds like a great note to end on. People choose robust regulation. So why don't we conclude panel 1? We have a 15-minute break before panel 2, and we're going to get to do a deeper dive into the same issues really regarding entities. Thank you. And thanks to all of our panel 1 participants. So I want to welcome our second panel for the day. I'm going to do what we did with the first panel, which is could we just go around and do a self-introduction of your name and who you're with. And this time let's start with, actually, we know Bob, but we'll start with Bob again. Bob?
Bob Riley from Shell Trading.
Good afternoon, John McCarthy from Getco.
Sarah Lee from Bank of America.
Angie Karna from Nomura.
Chris Allen from Barclays.
Hi, Steve O'Connor from Morgan Stanley.
Marcus Stanley from Americans for Financial Reform.
Wally Turbeville, Better Markets.
Marcelo Ruffo from Deutsche Bank.
Okay, I'm going to ask Dan Berkovitz, our General Counsel, to ask the first question. Get started.
Thank you, Jackie, and welcome to our second panelists. I'd like to start off with a question. It's somewhat a follow-up from much of what was discussed on the first panel, but perhaps we can get into it with a little more specificity on this panel. The question would be is specifically which activities should trigger, which activities outside the United States should trigger a registration requirement for a swap dealer. Would it be only the activities dealing with U.S. persons within the United States, or would it also potentially be activities with U.S. persons outside the United States? And then the second question would be, once registered, which Dodd-Frank provisions should apply? Should it be transactional requirements that would apply to specific transactions, or as you're aware, Dodd-Frank for swap dealers, major swap participants, not only has transactional requirements, but has a number of entity-wide requirements. Those would be capital requirements. Those could be business conduct standards, internal business conduct standards, as well as external business conduct standards. And, for example, the external business conduct standards would be how you deal with certain counterparties. Internal business conduct standards would be things like chief compliance officer, risk management procedures, documentation procedures. If you're a U.S. swap dealer solely dealing within the U.S. and you or MSP and you become designated, all those requirements apply to all your transactions. But if you are a swap dealer outside the United States who becomes a swap dealer by virtue of your dealings with U.S. persons, which of these transaction requirements should apply, which of the entity-wide requirements should apply? So first question would be the threshold question is which activities count towards the determination of whether an entity outside the United States is a swap dealer. And then the second question would be once the threshold is triggered and you become a swap dealer or MSP, which of the Dodd-Frank requirements would apply?
Right, why don't we start with Marcelo, and then we'll turn to Angie.
Thank you very much. I think the answer to the first question, which activities would make you a swap dealer, it's in the statute and the prior panel, the entire discussion about whether you're facing a U.S. person, however defined, or involved in a U.S. transaction, however defined, that would be what should give rise to whether you're a swap dealer subject to registration. On the question of what rules would apply at that point, I think it's the trivial answer is all of them. And but then when would you apply those? You would apply them. The entity-wide rules, by definition, apply to the entire entity at all times. So to the extent you're concerned about capital, it's entity-wide, and you're measuring it at all times. When you're talking about the transaction-based rules, that is where a swap dealer should need to be compliant only when facing U.S. persons on U.S. transactions. So a bank that has activity both with U.S. and non-U.S. persons, the transaction-based rules should attach only to the former category. That would be the proposal. And but that non-U.S. activity does impact the entity-wide activity, and so that's why you're measuring at the entity, all the other activity.
Angie.
Further, I agree with what Marcelo said about activities with U.S. persons. I would also take us back to the first panel. We think the definition of U.S. persons really should stem from existing law. And so, for example, one of the points that had been made earlier related to offshore affiliates or offshore branches of U.S. institutions. Under existing law, under securities laws, if Nomura's foreign dealer provides a risk management solution to a Japanese subsidiary of a U.S. company, or provides a risk management solution to a U.S. Investment manager who is managing Japanese risk for a foreign client, then we don't believe that the foreign dealer needs to register in the United States of America. We believe that that's offshore activity.
Chris?
Thank you. I agree with that. I think it does stem from the definition of U.S. person, and I agree with Angie's comments in terms of how one might look at that question by reference to existing law, particularly, for example, Reg S. I think going to the second question, though, as to what it might be that then kicks in under Dodd-Frank when one is on the face of it within the scope of the regime, it strikes me that quite usefully the distinction which Marcello identified between entity-style regulation and transaction-specific basis of regulation is an important one. Because on the face of it, you might obviously have the notion that if you're looking at capital and prudential regulation, clearly that only makes real sense when contemplated at an entity level. At the same time, I think on that score, it's important to recognise the importance of potentially deferring to home state regulators in circumstances where those home state regulators have a comprehensive and globally recognised standard of regulation of, for example, capital or other aspects of prudential regulation. And that obviously would be a test that would have to be satisfied on a jurisdiction-by-jurisdiction basis. When it comes to the transaction-level regulation, and obviously aspects of conduct of business that would fall within that, it strikes me as most useful to apply or to require that the overseas entity which is registered as a swap dealer apply those conduct of business standards in circumstances where it is dealing with a US person. So, for example, it strikes me as entirely sensible that a UK entity which is registered as a swap dealer but which is entering into transactions with a US investor should be required to apply US conduct of business standards to that relationship. However, the London entity of the UK firm enter into transactions with an Italian client, for example, it strikes me that the most appropriate conduct of business standards to apply there would be those that apply in Italy or potentially the United Kingdom, but certainly Italy.
I don't think I've actually got much to add because you've sort of said everything that I was going to say. So, no, I mean, I agree completely with Chris and Angie and Marcello, particularly as well in terms of the registration requirement really applying when you're dealing with entities domiciled in the US persons. And in terms of when that entity registered and how those requirements apply, I agree wholeheartedly with Chris that I think the distinction needs to be made between entity level requirements and transaction level requirements. And in relation to the entity level requirements, I do think some thought should certainly be given to comparable regulation of those entities in those foreign jurisdictions that they could be relied on. And at a transactional level, I think certainly transactional level requirements should be applied around business conduct, clearing, reporting to that entity's trading activities with US persons domiciled in the US, but not to the transaction requirements of that entity with foreign persons outside the US.
Wally.
We slipped into domiciled. Sorry. So I think it's clear that whether if you refer to U.S. persons, that's an issue that's very Dodd-Frankish and has standards, and from our perspective, domicile wouldn't be the issue. But I'm also sort of struck by what appears to be a thought that at the entity level kinds of regulation, capital and others, that the sense is that you would be a Dodd-Frank jurisdictional entity, but there would be some deference to other entities, which I think is the standards are another issue, but that being an approach recognizing there could be duplicative regimes that might apply sounds like a sensible one too. Is to understand which particular requirements are ones that are absolutely required by the U.S. regulatory regime, and others for which some sort of deference might be provided.
Brian, did you want to probe with regard to that a little bit?
So to sum up the answers, if it's regardless of whether the dealer is domiciled in the U.S. or overseas, it turns on whether the counterparty is a U.S. person. Is that what I'm hearing from the panelists? And if that's the case, which side of the line, so you're making a distinction between entity level and transaction level, which side of the line does margin fall on in that divide?
Robert, I don't know whether that was something you planned on addressing. Why don't I let you pick up and then maybe turn to Stephen, who I think is trying to be responsive to Brian. So go ahead, Robert Riley.
Well, first, just going back to the original question, I just want to emphasize that transactions between affiliates should not be covered by Dodd-Frank, whether in the U.S. or if they're between affiliates in the U.S. and another country. Other than that, I think that only entities that have a direct and significant connection with U.S. commerce ought to be covered, and I think significant means something. It doesn't mean a hypothetical connection. It means something that's very direct and very tangible. So I think some of the things you would look at in that regard are, well, gee, does a company have a U.S. presence? Is it trading in U.S. markets with non-affiliates? And what is its volume of bilateral trading in commodities with U.S. underliers?
Stephen, did you want to tell Brian on which side of the line you would place margin?
Yes. But before that, I think it's worth stating that we would all like all the rules globally to change on the same day and to be the same rules in each jurisdiction, with mutual recognition of authority between regulators of a certain standing, and mutual recognition of infrastructure such as CCPs and data repositories. And clearly we're not in that world, so that's where extraterritoriality comes in. And I think the US going first is fine, but the extraterritorial components of that are very important. And the most important thing is to reserve a level playing field within a market. So US clients, when trading with US or European banks, should be the same rules applying to both banks. And within Europe, I think US banks and European banks have to be treated the same as well. So specifically answering Brian's question, I agree with the comments made earlier that the transactional level rules should, with regard to European entities, should apply only to transactions with U.S. counterparties, and to the extent that European operations, for instance, of U.S. banks trade with European clients, they should not be subject to the Dodd-Frank transactional rules, including the margin rules. Because if they did, then you would not have a level playing field in Europe. European clients would be incented to not trade with those European operations of U.S. banks, which leads to reduced liquidity in those markets, reduced competition. Other consequences will be jobs and tax impacts in the U.S. U.S. banks would be hampered in their ability to nurture capital formation, including in the U.S., because the global reach is important to provide those services even to U.S. clients. You'd see the geographical shift of liquidity mentioned earlier from the U.S. into Europe, including for U.S. products, and U.S. regulators would have less visibility into global markets as product move offshore including into U.S. product, which itself might move more offshore. So I think the consequences of having an unlevel playing field in Europe was the example I gave, or in the U.S. would have profound impact on markets.
Okay, Marcus, Wally, then Ananda, and then Marcelo.
Yeah, I'm not sure we want to get completely hung up on this transaction entity level distinction. I mean, it's to a degree a real distinction, but our focus ought to be on the goals of on the statutory goals of the Act. And to me, it seems like margin, whichever side of the line it falls on the side of the line where you want to do it. Because fundamentally, the Act is meant to avoid a situation where the U.S. market is exposed to the risk created by the failure of a major derivatives dealer. And we know, because this entity has registered as a swaps dealer under Dodd-Frank, that it's doing activities that have a direct and significant connection to the U.S. economy, and presumably its failure would expose the U.S. economy to some negative fallout as well. And margin, here, the line between margin and capital, they're very interrelated to me, because they're both a means of sort of making sure that you have the funds available to protect yourself in case you end up very far out of the money on a derivatives transaction. And presumably, actually, if you weren't taking margin, your capital requirements should actually be higher. So I think it makes a lot of sense for the margin requirements to be in effect for anybody who registers as a swaps dealer under Dodd-Frank. And in response to Stephen's point that this would that a loss of business in Europe for U.S. subsidiaries would result in a hampered ability to provide capital to firms in the U.S., this goes back to something I said in the first panel, that to me this just demonstrates what global entities these are, that that profits and losses in subsidiaries can affect the flow of capital into the U.S. And I'd really want to see, if the profits are affecting the flow of capital into the U.S., I'd really want to see some very hardcore proof that the losses won't flow into the U.S. as well.
Margin, the philosophy behind the regulations, proposed regulations that are out there, is that margin is taken by swap dealers to protect them from harm along the lines of systemic risk issues, and like Marcus was saying, it's aligned with capital, so that would be an entity purpose. However, if you read our comment letters, we think there are other reasons for margin to be there. They just don't happen to appear in the proposed regulations yet. So we're hopeful that in the final they do. But at least there's an entity level purpose behind the regulations, and ergo margin is at least entity based.
Ananda?
I want to pick up on the point where Stephen made, which is, and I see the attraction of treating people the same, right? Irrespective of where you're located. In other words, Morgan Stanley, you should be treated the same as Barclays if you're both swap dealers. And I think the point you made was, we should only regulate you for your activities with other U.S. persons on a transactional basis. I think that was the point that's being made. Now, the question is this. If we accepted that proposition, basically what we're saying is whatever Morgan Stanley does outside the United States does not have a direct and significant connection with activities in the United States. Because that would have to be it. And so I'm trying to reconcile the approach you're suggesting with our duty to enforce a statute.
Right. And I understand the struggle you faced. But also the G20 talked to having a level playing field and not creating situations of regulatory arbitrage. So I think to some degree there is a balance needed here. And the point made about financial institutions being global entities is quite true. So the point I made at the outset was that ideally we'd want to have the same rules in all jurisdictions, and I think energy should be spent on trying to reconcile the rule set and the timing between the Europe and the US primarily, but other jurisdictions as well. And that's the solution to regulating global entities, rather than going first. And as I said earlier, going first is a good thing. It shows the US is taking a lead. But going first and then hampering the businesses of the US banks seems to be will be harmful and is the opposite of protectionism, basically.
To follow up on what Ananda has just said, and to pick up on a couple of points that Wally made earlier, I haven't responded to the approach whereby you don't defer, or there is no deference with respect to the conduct rules. One, because there is a timing issue. In other words, what are we deferring to? Two, why not have complementary requirements, whereby the requirements are more or less the same, at least in terms of outcomes, without necessarily having to defer to a home regulator at the entity level? I think that's what was being suggested. I think it's probably worthwhile to try and respond to that point, as was raised by Wally. So I see a number of flags up. Chris, Sarah, I think, was next, Angie, Wally, and then Marcelo.
I was just going to comment that it strikes me that when we talk about potential deference to home state regulation, that's not some way a suggestion that the standard that should be applicable to that institution should be in any way less, because I think it is quite important that that approach be underpinned by an acceptance by the US regulators that the overseas standard of regulation is appropriate, comprehensive, and conforms to requisite global standards in terms of the integrity of that regulatory approach. And if that is not the case in terms of the overseas regulatory cultural approach, then that recognition would not be in place, and the capacity to defer, I would suggest, wouldn't apply. So I think there is a safety mechanism, if you like, embedded within that. I'd also like I agree with the comment, I can't remember who it was made it, that there is obviously a very close nexus between capital regulation and margining, in that, of course, the less collateral an institution swap dealer holds on its book in relation to its counterparty trading lines, so the amount of risk-weighted asset and associated capital it has to put behind that business increases significantly. So, of course, there is an important connection between those two concepts. It doesn't necessarily strike me, though, that takes you to the conclusion that one should look at margin from an entity perspective, because it strikes me fundamentally that it does fall within a kind of conduct of business conceptual type of rule. Because not least of the difficulty that derives from the fact that different regulators around the world are also looking at that same question in terms very much of the conduct of business standards that should apply to dealers and market participants in their respective markets. If you take the European example, which is the one I am closest to, and the EMIR regulation, which provides for, among other things, principally trade reporting and managed clearing of OTC derivatives. Of course, one of the provisions in that regulation, which I appreciate is behind the US in terms of timing, but is still relatively progressed, specifically contemplates margin requirements for uncleared transactions. And I think trying to apply in Europe between transactions entered into by a swap dealer registered UK entity and its Italian client, for example, a margin requirement which was in any way different to the one which was required to be applied by the UK and Italian regulators to govern that relationship, I think could be highly problematic.
Sarah.
Yeah, I wanted to touch upon margin requirements as well. In particular, I mean, a lot of people have been talking a lot about Europe, but less so about Asia and where that market is at the moment in terms of its margin requirements. I mean, Asia is still what I'd call, many Asian jurisdictions are still in the very early stages of derivatives development. So they don't yet have the fully baked market practices that we might see in the West. So jurisdictions like China, India, Taiwan, currently don't have market practice to call for margin in those jurisdictions. So I think one of the challenges that we face is if we require a margin at the entity level, it becomes difficult then for entities that have registered in the US to operate in those jurisdictions because local banks will not be asking for margin. And so to manage the risk of trading activity in those jurisdictions where there isn't margining, capital, as Chris was referring to, can be used as a tool to help manage the risk of those jurisdictions not yet having the same sort of margining practices that we see in the rest, but then allowing global institutions like ourselves to be able to operate in those jurisdictions.
Chris, was that a two-handed intervention? Did you want to follow up very quickly on what Sarah just said?
No, I agreed with what Sarah was saying, but the point I wanted to make was a potential consequence or conclusion if one pursued the notion of margin as an example applying to at the entity level, which is touching on a point which was raised in the first panel, which is the potential fragmentation at legal entity level of the different participants in the markets in a manner which could be unhelpful when it comes to a host of issues, but not least portfolio margining, taxation, and capital. Because if it were the case that the requirement to comply with Dodd-Frank margin rules for a European entity brought that entity into conflict with obligations it might have under the European regulatory regime touching on the same issue, there may be an inevitable consequence of that, which is that in order to be able to continue with both European and the US businesses, the entity in question has to subsidiarize its operations. And that strikes me from a capital, netting and various other perspectives potentially unhelpful, and also query where does it really take the systemic risk debate further forward.
Angie.
Yeah, actually, Chris mentioned one of the things I was quite focused on as well. You had asked the question earlier, Ethiopius, about what's the consequence of no deference. For us at an entity level, the consequence of no deference is the line of the spectrum that was mentioned at the beginning of today, which is isolation and specifically subsidiarization and having regionalized pools of capital and a lack of liquidity for global end users and global end clients who want to access markets in different jurisdictions. So we think it's critical that there be deference at entity levels, and for us, capital is a primary example, and we agree that margin and capital are linked and raise challenging questions. But we also agree that a level playing field is critical for functioning markets globally and for U.S. investors and end users of derivatives to be able to access those markets globally.
Angie, can I press just a bit on that point?
Sure.
To ask why deference if the requirements are complementary and indeed may be highly comparable? In other words, as long as the standards are comparable, need there be deference in terms of saying we're going to simply leave it to you to oversee the entity, whereas you could, if there were complementary requirements, have a relationship whereby it is a coordinated, collaborative effort on the part of the regulators?
Capital, to me, is the fundamental issue. And there are global capital standards that all of the major global institutions are applying based on their local regulatory interpretations of those standards. So capital is assessed for an entity at looking at all of its risks, not just a piece of its risk. And when I speak to risk managers at Nomura or anywhere else, they tell me that they speak Greeks, not grids, and that they look at capital and they look at risk across all of their entities. So it's very critical for us to manage our risk and manage along one set of rules, not slight differences in rules between different jurisdictions.
I see a number of the regulators have raised their flag, so maybe I'll turn to them quickly and then turn to the other side of the table. So I think, Jackie, you had your flag up first, and then Dan.
I just wanted to follow up on something actually Sarah said, that I'm hearing sort of two different lines here. One is that, in Europe, we want you to defer on the entity level regulations. And Sarah pointed out the Asian situation where maybe they won't have margin applied in the same way, or margin at all, as it's developing an OTC market. And so my question really is, in that situation, are you saying that we shouldn't defer because there isn't something to defer to? I mean, you were saying there's a competition concern you have, but if we completely leave that unregulated, then we haven't done our jobs, have we, in the systemic risk oversight?
Yeah, I wasn't saying that you should just ignore that situation, but I think there are other tools that you can use instead of margin to manage the risk of that trading activity, which is unmargined, which is capital. And that you can hold more capital in those jurisdictions where you don't feel that the regime is the same as the US or the margining requirements are the same, which still allows participants to operate in those regimes by following the local requirements for that trading activity, but also balances that with the capital that's held against that perceived increased risk.
Dan?
And intrigued by the notion that it's simply a question of the capital requirements, entity-wide capital requirements. In Dodd-Frank, at least for the U.S. swap dealers, the bank swap dealers, there are the capital requirements, and that will be determined by the prudential regulators. But then there's also the other entity-wide business conduct standards in terms of risk management documentation, the other entity level. We call them on prudential regulations. I guess to take that approach would be almost for us to say that those are not of any significance in terms of any level regulation or systemic risk reduction. How would we get beyond that hurdle of basically saying these are not necessary for prudential regulation of these or entity-wide regulation?
Just because you're looking at me, I think you think I said something earlier that I didn't say. I think capital is the quintessential entity level requirement, but not the only entity level requirement. For example, our internal conduct standards, our chief compliance officer standards, our walls and our barriers can only be assessed at an entity level as opposed to at a transactional level. And so I think that there's a host of issues, and those are other examples of what I would consider to be appropriate prudential standards that, as Chris mentioned earlier, I wouldn't expect you to defer to all of those prudential standards without an assessment that the particular regime has appropriate and comparable standards to what you would expect in the United States.
Marcelo, you've been waiting patiently.
That's okay. Most of what I was going to say has been said. Thank you, Ethiopius. Let me take your question, Dan, consistent with what Angie just said. We think of the entity-wide rules as when we say deference, we're not saying that it's a complete delegation, right? We're saying that you've made an assessment consistent with what historically has been done in the banking sector for cross-border banking supervision. There's an assessment that there's comfort, there's comparability with the home country regime, right? And then, so there should be some comfort there to defer to the home country regulator. The rules, though, that are entity-wide, some are more prudential than others. Some go to capital, centralized risk management, et cetera. But then there are some in Dodd-Frank that are less prudential in nature but are still entity-wide. So CCO rules, conflicts of interest, diligent supervision, right, monitoring and trading. Those are rules that the deference there, if you choose not to defer, those are rules that when you promulgate them, you should think seriously about adopting a flexible approach that accommodates pre-existing organizational structures and approaches that we have in our home countries that have been required or that we have put in place to comply with our own local regulation.
Thank you. Wally.
Margin and capital are related, but they're different. They're not transferable. Margin is micro. It's about transactions and correlations and offsetting and all that good stuff. Capital, proper capital should assume, it should be set at the level required, assuming that you actually margin like a sane person. So those are two different things. However, they both, under the philosophy that's being adopted by our hosts here, have to do with entity level. For instance, the Asian transaction, what's the problem with it is you would allow a company to have a subsidiary in Asia who could run up all kinds of exposure, unmargined exposure on transactions which then blows back on the U.S. entity. And the whole point of margining, as it was set up, was to protect that entity. So in other words, that's what the real issue is that the margin requirements were set up to protect entities, and allowing extraterritoriality issues that aren't necessary given and even reasonable given the actual statute to come into play. You allow that whole policy to be undermined, right? So margin, capital, two different things, and we shouldn't ignore the fact that a dealer in the U.S. is supposed to get margin for its positions in order to protect it, in order to protect the whole economy.
I'm going to turn to Marcus, then John, and then I think we've exhausted this series of questions, and we'll move on to the next, and Jackie will get us started. So, Marcus?
Well, Wally really said a lot of what I wanted to say there on margin and capital. They're related, but they're not the same thing, and they have complementary strengths. And just seconding what Wally said, I'd also point to the experience with risk-weighted capital before the crisis, when capital requirements were arbitraged very significantly, and it's much easier to arbitrage a set of capital requirements for the entire entity where you can have claims about hedges that are being made across many, many different subsidiaries, where there's a lot of complex processing where you're trying to put all of the entity's exposures into one number. Whereas with margin is something that happens at the transaction level but contributes to the health of the whole entity, because you're forced to take some margin for each and every transaction. So they are different. It's a belts and suspenders approach that was clearly contemplated in Dodd-Frank. So, and the only other point I wanted to make was that there was some discussion of regionalized pools of capital or fragmentation around the world. Well, a goal of Dodd-Frank is to shield or protect the U.S. economy from practices that create excessive risk. And frankly, if we get some fragmentation where you have one market over there which is not taking margin, which is engaging in risky practices, and then connections from that market into the U.S. economy are perhaps reduced or cut, that's, to me, perfectly in line with what Dodd-Frank intends.
I said John, I meant Robert. Apologies. And then Jackie.
That's fine, just as long as you smile when you say it. First of all, I think margin requirements should be transactional, but I think we should take a step back and remember we're talking about margin requirements on uncleared swaps. And so really, to me, the first question is, if we're looking at different countries, are the clearing requirements comparable? Will other countries have something that looks like our end user exemption? How about hedging, and how does that fit into the end user exemption? So all those things have to be lined up if we're going to take something other than a non-transactional approach to it. The other point I would make is that for non-banks, swap dealers that are not affiliated with banks, the capital requirements are very much tied to the level of uncleared swaps. So to the extent you don't have a cleared swap, the capital requirement does go up. And so there is a bit more of a relationship between margin and capital.
Okay, thank you. Jackie, if you may get us started on the next series of questions, ma'am.
This morning, we spoke a little bit about branches and affiliates and subsidiaries of U.S. parents, and I want to dive into that a little deeper regarding registration. We also talked about direct and significant effect on the U.S. And so my question is, when should a branch, and you can treat these differently, affiliate or a subsidiary of a U.S. parent located abroad, be subject to registration? Should it depend on just the fact that there is risk transfer to the U.S. parent and thus there's a direct and significant effect on the U.S., or should it be subject to the level of trades it has with the U.S.?
Thank you, Wally.
I was waiting. I wanted to counterpunch. The answer is affiliate branch, the issue is not about that. The issue, to me, it's a two-pronged issue. One is the risk effectively of that entity effectively transferred to the U.S. Bank? And the second is, are they in effect the same businesses, right? So so guarantees, those sorts of issues are very important. But also, are they the same business? Do they run a consolidated book? One of the things that is talked about here is the agony of having to use subsidiaries. The other thing that gets argued about in this whole area is, well, we want to consolidate our books with our subsidiaries. So, I think the fact is that it's probably most books are consolidated of the banks that we're talking about here. That infers strongly that it's all the same business, and it's not that hard to consolidate books with disparate branches and affiliates involved. So I think in most cases, it's actually going to be the same entity. That's just based on what I've heard people say, but that is the test as far as I'm concerned. It's not a question of where is it organized, is it a branch, is it an affiliate? Is it the same business? Is the risk transferred?
This time, John.
Yeah, I mean, GetGo is a firm that trades only on centrally cleared exchange traded markets, and I'm sorry. So if we're required to if we're required to register affiliates in Singapore or London simply because we're a U.S. based market maker, it will put us in a unique position vis-a-vis those liquidity providers that are obviously located only in those other jurisdictions. And we would, I don't want to say we would have we would obviously have additional requirements, but we basically have to comply with two regimes. And I think it's fair to say that could put us at a competitive disadvantage in terms of just burdening us with costs that our competitors would not have. And it's a very, very competitive environment in both the UK and in the Asian market. So again, a lot of the regulations would be duplicative and probably could leverage off each other. But again, I think it would put us likely at a disadvantage in my judgment.
John, wouldn't you just put a UK holding company over GetGo and have the foreign affiliates subs of the UK holding company, thus getting out of this?
We could do that, and obviously there's costs associated with that. But again, it seems to be is that really the preference that the regulators want for us to kind of create, a much more. To create an infrastructure that is only designed to basically avoid registration. It just doesn't make sense to me. But
yeah, I'm not suggesting that's the preference. I'm trying to get at if we're making a distinction. Is it really turning on who the parent is and where they're located?
Yeah, and that's with our outside counsel, that's kind of a suggestion that they've made. But again, it seems to be hopefully unnecessary. Is what my guess is.
Thanks for stirring things up a bit, Brian. Marcelo?
Yeah, I have a problem with the whole idea that if and I don't have a dog perhaps in this particular fight, let me start with that, but if I'm a U.S. company and I set up a subsidiary overseas for reasons of employment rules, local tax rules, etc., and I'm engaging in a swap business, absent my guaranteeing that subsidiary's performance, I don't see why that should subject it to registry, and it's doing offshore business, so it's not dealing with U.S. persons. I do not understand why that should subject that subsidiary or the parent to registration under Dodd-Frank. I don't see that. You could get there perhaps in some other odd way of Dodd-Frank. I don't know if you think that somehow it is such a material subsidiary and the U.S. entity is somehow a SIFI. I don't know, but from the perspective of Title VII, I just do not see that. I do not see that happening. And I would go a little bit further. I'm not entirely sure the guarantee carries you into a conclusion.
Well, nobody's spoken to Ananda's point. from earlier, where he raised the directness and the significance and the impact on the U.S. marketplace. So it is very possible that you would have an entity that is not U.S. based that has enough of an impact such that your answer or your conclusion is different. And maybe Ananda has raised his flag to say it again and probe a little bit more. So I'll turn it to him.
The other concern is, let's say that there is a concern that if our reach did not go into a subsidiary or an affiliate, that's the way you structure business. I'm not saying any of these fine companies here will do that, but let's say you have another company. That's how you'd structure your business to avoid whatever it is, Dodd-Frank. Right? That you would not do any business out of the U.S. bank, but you'd rather do it out of your subsidiary. Now, is that realistic? Number one. And if you guys are saying, no, never going to happen, then maybe we should think, that will affect the way we think.
Given that challenge, why don't we start with Stephen and then Marcus?
So I think that to start booking business offshore to escape the reach of Dodd-Frank wouldn't help with regard to U.S. clients, right? Because those, by the fact the clients are in the U.S., that would capture they would be captured by the transactional level rules of Dodd-Frank. And I think, though, where we're going to end up, which is a trend we've seen already, is that when trading in a particular jurisdiction, that banks globally will tend towards booking transactions in a legal entity in that jurisdiction. So, but I don't see that as being arbitrary or rule avoidance. I think if European subsidiaries of U.S. banks trading with European clients, I think that's a fact pattern that's fine, as is booking U.S. client business onshore in the U.S. in a branch or subsidiary for overseas banks. So I think that you will see that pattern developing, but I'm not sure it's avoidance. It's more just centering businesses in the right jurisdiction and local, as mentioned earlier by Marcelo, local tax rules or business conduct rules or regulation might force that even more than it has been in the past. But I don't think, by virtue of the fact that the clients in the U.S. will be captured whatever, I don't think there's a good tool for institutions not in the room to employ with that regard.
Marcus?
Just in response to what Marcelo said earlier about the guarantee, although he seemed to imply that even if there was a guarantee, it wouldn't be appropriate for the subsidiary to be regulated. We really have to make sure, I think, we have the tools here to avoid kind of a Cayman Islands situation. And I think the burden of proof needs to be very, very much on the bank itself to show that the U.S. entity is not going to end up being responsible for those losses. As I said during the first panel, before the crisis, the argument was made, this was the whole justification for off-balance sheet entities, was that the parent company would not be responsible for their debts. And of course, no one would have loaned to them unless it was known that implicitly the parent company, through a wink and a nod, actually would be responsible for their debts. And indeed, the parent companies did have to take those entities back on their balance sheet when they got in trouble. So you really want to see an ironclad wall here, it seems to me, and you want the burden of proof to be on the bank that's claiming that subsidiary is fully walled off in order to really demonstrate that.
This affords me an opportunity to ask a question I had wanted to ask during the first panel of Thomas from Goldman Sachs, and I think he had suggested that Yeah, well, I'm asking you now, though. He had suggested that guarantees, in essence, were a surrogate for regulation. And now that you have regulation of all these entities in the derivative space, that it may be less necessary. But the question I had was, so have we seen them disappear? Are there guarantees still being provided and asked for? And I think that's a question probably I'd like to hear an answer from a number of people around the table. So, Sarah, since you have your flag up, why don't you go first?
Sure. But I just, first of all, I wanted to answer Ananda's question. I mean, we are Bank of America, so I think it's going to be difficult for us just to suddenly up sticks overnight and become Bank of Singapore or something like that. I mean, we have a massive customer base in the US, and it would require all those US customers just to move offshore as well. And I think the key points that I want to make is in terms of how we've set up our business, and I'm sure many other large financial institutions are the same. We set ourselves up with subsidiaries and branches around the world. In Europe, we have subsidiaries that we operate out of to comply with European passporting requirements. In Asia, many of the jurisdictions either require a local banking entity or a foreign branch of a bank to operate onshore in those jurisdictions, and those subsidiaries and branches have been set up for decades, operating for legitimate business reasons. They were not set up to evade Dodd-Frank, and I think I do want to re-emphasize the point that if we, I know we've got this challenge that the US is first at the moment, and the laws around and regulation around the world is at a different pace. But I think the challenge for us as a US financial institution is if we are required to comply with the US rules in those foreign jurisdictions with our foreign clients, we will struggle to continue to do business in those jurisdictions, and we will struggle not only to compete but also to manage risk of those transactions, to be able to book and manage the risk in those jurisdictions. So I recognise that it is a challenge in terms of how do we deal with ensuring that we as an institution are safe and sound, particularly as we own companies all around the world. And again, I go back to my point, I think it's important that we use tools, other entity level tools like capital, to manage that in this interim period while the rest of the world is sort of catching up with their regulation.
Angie, and then I think I'll turn to the regulators who raised their flags, and then Chris and Stephen. So, Angie, why don't you go first?
Sure. Just addressing your question, Tom's earlier point, and something else that was said, it's important to re-emphasize that one of the changes in Dodd-Frank that is not going to go away is we are not going to be able to do swap dealing activities with U.S. clients out of unregulated entities, period. We could pre-Dodd-Frank, we can't now. And that's a fundamental change that we can't lose sight of. I don't see any discussion about comparable standards abroad will also be referencing, for all of the institutions in this room, well-regulated entities, and we wouldn't expect you to ever sign off on an unregulated entity. And in fact, we have 3 primary trading entities around the world, all of which are regulated. All of which will be regulated post-Dodd-Frank. Our U.S. entity actually is the only one that hasn't been regulated, but our majority of our business is done out of our European entity, which is regulated, and our Japanese entity, which is regulated. So I wanted to just highlight that is a distinction with pre- and post-Dodd-Frank. In the United States, we're not going to have an unregulated entity facing U.S. clients.
Dan?
Thank you. I'd just like to follow up on a point that was made about a European affiliate or subsidiary that is, or in any foreign jurisdiction that is set up for tax reasons, whatever reasons, and that if it's really a separate entity, then the Dodd-Frank requirements shouldn't apply. But then we get into the question, on the other hand, of inter-affiliate transactions where entities are also asking at the same time, although that these, for certain purposes, that these entities are considered separate entities and don't apply Dodd-Frank requirements to the other entities, and yet for the inter-affiliate transaction, exception, for lack of a better term. We're also being asked to provide an exception because really they're the same entity, and this is just distributing risk internally, and we just want a single entity to face the market. And yet, not all of those single entities are being regulated when they face under Dodd-Frank when they face the market. So I'm just wondering if there's a disconnect or an incongruity between, on the one hand, not applying Dodd-Frank to an affiliate or a subsidiary because it's established in a different jurisdiction, and also at the same time requesting an inter-affiliate exemption from clearing requirements and other requirements to Dodd-Frank because they're really the same entity.
Let's take some answers to Dan's question and then turn to Jackie and to Robert. So
You're asking me, Dan. We're just asking for a lot more than we should. No. When I think of the inter-affiliate transactions, and I may be coming at this from my own paradigm, for us it's inter-branch, right? So we don't have this situation where we have a subsidiary that is doing swaps. We book all of the soon-to-be regulated businesses in branches of our branch, New York branch, London branch, branches of our home bank. So when we think about inter-affiliate transactions, regardless of the initial trigger to the market, whether it's a U.S. person or a non-U.S. person, we think of it as moving the risk within the same legal entity from a corporate structure and from a credit exposure perspective, but across branches, which really are regulatory concepts that come out of the banking world. And therefore, at some level, it's tantamount to a journal, but you need to have good books and records to manage it. And it all serves centralized management. You have human resources that have the right expertise in particular jurisdictions, et cetera. So you want to have the same risk management, risk compliance function over it. So you move it to the logical central location. But you do make a good point, and I do not know the answer. If I have a subsidiary that's doing business outside and it's on a U.S. asset, and you end up doing truly inter-affiliate trades, different legal entities, back to some central book, it's a good question. Now, I would say that if one of the entities that's receiving that, if it is already a regulated entity, it has its own, that's an exposure that it has its own capital that attaches to that activity. There may not be inter-affiliate margin, but it needs to manage that risk. There are prudential rules that already attach to that. So I'm not sure I see an end run unless it starts at an unregulated entity and ends up at an unregulated entity.
Wally.
To me, that's all part of the same issue of, is it a common business? Is how the inter-affiliate transactions work? Because I think, in fact, it will track back to what is the real business involved. So if the real business is a U.S. bank and there are subsidiaries and through inter-affiliate arrangements, it becomes obvious that the whole thing is run, risk management, personnel, everything is run from one entity, and the risk is in one entity, and the profit eventually gets to one entity. It seems like that should be the same entity, and the results shouldn't be any different if a U.S. domiciled company does an activity as opposed to a subsidiary who then has that kind of relationship with the parent. The results should be the same as far as Dodd-Frank goes. And I think in actuality, whether it's branches or not, it just makes it's actually, it should be expected that in a lot of these organizations there are centrally managed books. Risk is centrally managed. The risk professionals are in common, and ultimately the profit and loss is a result that's important to the parent. So in fact, why it's really important, that's sort of how it all works. And it just strikes us as not being sensible that, in fact, yes, all the subsidiaries are out there, the branches are out there, for regulatory and tax and other motivations. But if the business is really in one place, that's where it should be regulated.
Chris, I realize you had your flag up before Dan's question. I don't know whether there was something else you wanted to get to before we moved on, or whether you want to get to that as well as Dan's question. Well, why don't I turn to you?
I think I'm about 3 questions behind, actually, in terms of the list of notes I've made here. But just very quickly on the most recent question, I mean, I think there is that tension. I think there is the difficulty embedded within that dual ask. But I would just comment, though, as a bit of a qualification to it, that even in today's environment, entities don't just liberally take exposure on a kind of intragroup basis without proper consideration of a number of the factors that can really drive whether that makes economic sense to do, such as capital. Because, for example, there are many circumstances, it depends where the entities are located as to how this exactly plays out, but there are circumstances in which if a US and a European entity take derivative exposure to each other which is not collateralized, then you can attract a one-for-one capital deduction in respect of every dollar of exposure that sits behind that relationship. So there are other incentives which go beyond what we might describe as conduct of business or other forms of application of the rules, which will incentivize behaviours which are already there. And so I'd simply encourage that those be borne in mind and factored into the consideration for this point. The other point I just wanted to mention was, it was 2 very brief things, if I may. One was the motivation behind European incorporation, for example. Somebody touched upon the passports. It's hugely important for firms, both those that are outside the European economic area and also those that are within it, quite frankly, to be able to avail of themselves of the passporting rights which you can obtain under the Banking Consolidation Directive or MiFID, depending on the type of entity in question. And those are very solid reasons for wishing to incorporate and establish in European countries if you are intending to have a client investor base which has a European focus to it. And the final point was, I think Stephen may have mentioned this, but it's just to reiterate perhaps the obvious point, which is in circumstances where you have that non-US incorporated entity, of course, as soon as it touches the US in terms of whatever formulation of the US person test we apply, it is, of course, straight back into the realms of the relevant conduct of business rules that would be required to govern that activity. We've already talked about prudential regulation and how that might be subject to home state deference. But as we mentioned before, that would only be in circumstances where the US authorities were satisfied that the standard of that prudential regulation was comparable and robust. Thanks.
And is your flag up from last time, or is it up again before I turn to Jackie?
I think it's still relevant.
It's not a trick question.
It actually relates to Dan's question and also what Chris just said. And just following up what Marcelo had said earlier, we are an institution that does not have branches. So I just wanted to just clarify the facts around intra-affiliate trades for us, since we don't have branches, and Marcelo was talking about branches. As Chris said, whichever regulated entity directly deals with a U.S. client will be registered under Dodd-Frank. That U.S. client, however, may like the typical reason why we would have intra-affiliate transactions is because that client wants to get exposure to an asset class that is risk managed more appropriately in another region. So from the first panel, an institutional investor who wants to risk manage a risk in Tokyo may enter into a swap with the entity that directly transacts with U.S. clients, but that entity will do a back-to-back swap of that Tokyo best managed risk with our Japanese broker-dealer. So it's not just that it's the same legal entity. The entity that is facing the U.S. client will be well regulated, and we see no reason why, because that client wants to get exposure to something that is best risk managed in another region, why that intra-affiliate swap should be subject to additional regulation.
Okay, I'm going to take questions from the regulators. So we'll take a series of questions here and then turn to the panel. So Jackie first, then Robert, then Brian.
Before we completely shift from this topic, I just had one more follow-up, and it had something to do with what Steve O'Connor said earlier, which is that businesses set up affiliates and subsidiaries and have them today in foreign locations for legitimate business purposes. But the SEC and CFTC both have an anti-evasion provision in the statute that allows us to apply Dodd-Frank regulation to anticipate evasion or to prevent evasion. And my question is this: how do we determine what is a legitimate business shift? So doing business out of your affiliates with other U.S. Parent affiliates, and what is an evasion? So I look to our panel experts on this question.
Why don't we answer that one first before we move to Robert and Brian? So how do we judge anti-evasion? Starting with Marcus.
I think it shouldn't revolve around the subjective motivation of the entity for moving for perhaps creating a subsidiary or taking an action outside of the U.S., because there's always a set of reasons that one can cite for that. It really has to go back to the basic goals of the statute in terms of protecting the U.S. economy against risk. And if there's an action that would end up, that has the capacity to rebound on the U.S. economy in a significant way, then it really doesn't matter why the entity started to take that action in the first place. It's evading the goals of the statute.
Marcelo.
Thank you. I disagree a little bit with that answer, maybe a lot, but it's disagreement at whatever percent. I do, in fact, think that scienter matters when you're talking about evasive activity or not. I think it's one thing for someone to create a shingled entity incorporated in a foreign jurisdiction and not do everything that one would normally do to when you create an entity to actually go into business in the foreign jurisdiction, which includes registrations, human resources, a physical plant. There's a lot that is present when you're not in an evasive mode. The fact that someone chooses to create an entity and conduct non-U.S. business outside of that entity as a subsidiary of the parent, of the U.S. parent in a foreign jurisdiction is not per se evasive. The minute you touch a U.S. person, as we've said repeatedly, you now have U.S. rules that will attach. So your concern, and I don't think it's invalid, but your concern is going to something that's more systemic, right? Is there something systemic about that? And at that point, you go back to significant and direct effects. I see that as a very high hurdle to pass before you get there. We had a little research done on significant and direct effects, and it is not merely an adverse competitive effect in the U.S. market. It is more. It would be manipulating a market that has effect in the U.S. Something of that significance.
Your approach makes it not a matter of policy, but a matter of law enforcement. I mean, scienter, in essence, would require that we investigate and make a determination that there was the intent to not comply with knowledge and forethought. Is that the right line to draw? Is the right line to draw as between policy and law enforcement and to fall on the side of law enforcement? Or is the anti-evasion consideration something that goes beyond simple law enforcement? And I'll let you go, and then if Wally wants to jump in,
Okay, just one answer. I find, because I come at it from the position of scienter and evasion, I don't think you can conclude ex ante that that there is evasive activity occurring.
Wally.
About 3 decades ago, I went to law school. Scienter is a term of art that, as I recall, is a term of art that has a fairly high level of proof required to it. So that's a loaded term, and I see nothing in here that would suggest that you have to have scienter to meet this standard. There are levels of intent and mental approach to things, and scienter just isn't. So I understand what's being said, And I understand that the level is being set high for a reason. The other thing that I wanted to say is just everybody remember, there's for both the SEC and for the CFTC, there are two completely separate things going on. One is the evasion issue, and the other is, do the activities have the requisite effect, or is there a business going on from the SEC side? So there's two different things. So the evasion is a different kind of activity, which assumes that the first test, which is the activity that has the effect on the economy going on, or is there a business being conducted that's a U.S.-based business in reality? If it's not caught by one of the first tests, then it might be caught because there was an evasionary purpose to it. So basically, two things: two levels of tests, and scienter is not necessary in my view.
I see nobody else volunteering to answer this question. Maybe we should then turn to Robert to ask his question, and then to Brian.
Thanks. I wanted to ask a follow-up question of Stephen about something Tom said. No, it's something I think you said, Stephen, and it has echoes of something that Angie was touching on too, I believe. But I think you said that, and correct me if I got this wrong, that you think we may be heading towards an approach where global firms have a local entity that faces the counterparty. And I presume that part of that general model would be that essentially client risk is being managed local to the client and market risk is being managed local to the market. So U.S. counterparties would face a U.S. entity, and if the risk was dealing with a European underlier, that would be moved over to Europe where the European experts could manage it, and vice versa. And that might be a way that the market will evolve in light of the direction you perceive the regulatory environment moving. So first, did I get that right? Do you think that's where we're heading? And welcome other people to comment on this as well, these questions. Number two, is that a good thing or a bad thing? Are you saying we're heading that direction and it's unfortunate, or that that's a logical place for us to end up, and that in a way that resolves some of these questions? And I guess, how does this compare to the concept of one global booking entity in terms of from a policy perspective, the advantages and disadvantages?
I'm conscious of time, Stephen, so I want Brian to get his question in as well, and if we can answer all the questions at the same time.
This is a really important question.
I've been overruled, Stephen.
I think, yes, you correctly interpreted what I said. And this has been the situation for a long time, but for varying reasons. Typically that local clients are more comfortable with a local entity, the local regulations or tax rules or other might require that, or capital treatments also. So, but I think the trend will accelerate to the extent that, for instance, financial institutions had previously booked European client business in U.S. entities that might now get booked more in Europe. And I think those drivers that I mentioned, that you mentioned, are the correct one. Another one might be that clients typically would have one master agreement with a local entity. So to the extent that they traded in multiple markets, that's a case where there'll be a local entity with the relationship and the principal counterparty risk, but then the market risk would be better managed elsewhere around. So that's why you get the inter-affiliate transactions. So I think it's a trend. It's a model that has always existed, and I think that will continue to be the trend. As to whether that's good or bad, I think I go back to my opening point, which was to the extent we can have harmonization of rules and proper recognition of the jurisdiction of co-regulators around the world, then I think that's an okay outcome.
Sorry, but the second part of his question, I'm not sure I understood the answer to it. In other words, you're going to have local entities to manage local risk. What does that mean for global risk management at the end of the day? Is that something that will be complementary? Can it be done in a complementary fashion, despite moving towards local entities for managing?
No, I think it can be, but it does involve inter-affiliate transactions that we mentioned earlier. So, if you take the case of a bank or a client in Europe that has its main relationship with a bank entity in Europe, be that a subsidiary of a US bank or a European bank, then that bank will probably have trading desks in the US for certain US product. And I think it's most efficient and provides most liquidity to markets if all the risk in the US product is managed in the US. And so that's how you see these patterns of booking entities evolving. Is that can be done? It is done today, and will be done in the future. And just picking up actually on something that's said earlier, I think that the capital is the key here. I think it was Angie who said that, and I would agree with that. I would also disagree with the point made that capital and collateral are both needed. I think it is, as someone who's been fairly close to development of BIS, I think that the capital regimes, as they've evolved over the years, have one goal, and that's to ensure that the financial institution, at the end of the day, is robust, and to the extent there are counterparty relationships that are not margined, then capital goes up, and it goes up punitively with regard to inter-affiliate transactions, as mentioned before. So if you took a look at global institutions now, you would see in many cases that banks voluntarily decided to post margin on affiliate transactions to keep risk down from a capital perspective. So I think that the models exist today. They will continue, and it is possible to manage risk on the one hand from a global perspective, and to have the client relationship booked at the local level.
So Wally, then Chris, then Angie, and then Marcelo. So Wally.
Banks have crude oil desks, natural gas desks, interest rate desks, Japanese desks. To me, it's of course there are different ways to compartmentalize risk and to address them, and the people who have a good handle on those kinds of risks should be responsible for doing that. But then there is also the global risk issue, and certainly the fact is that the business, if the business defines itself globally, then that is the entity, that's the one doing business, that's the one that should be the focal point. And unfortunately, in a perfect world, all regulation would be completely harmonized and uniform, and all of these, there wouldn't be any difference between the crude oil desk and the interest rate desk versus U.S. business and Japanese business. But having said all that, it isn't true. It isn't. We do organize ourselves territorially. So, but the fact is, that's why the argument for the greatest flexibility possible, and not shutting yourself off with universal rules that create definitions that are very restrictive, I think is so very important in this area, because one would want to replicate as much as possible a harmonious regulatory environment that recognizes the international quality of the business.
Thanks. I just wanted to reiterate the point which Stephen made there about that relationship between capital and margin, because it does strike me it is important, even in the context, as I mentioned before, of intragroup transactions, because the capital consequence of not collateralizing those transactions on occasions, depending on the fact pattern you have, can be very substantial indeed. And so there is that embedded incentive to consider collateralization on an inter-affiliate basis over and above a conduct of business requirement to do so. The other point I just wanted to make, though, and it's slightly at variance with Stephen's comments about the use of local entities. Obviously, there are institutions that are organised that way, but I just wanted to make the point that there are a lot of organisations that are organised completely differently, according to a universal banking model with universal booking centres that tend to use a single legal entity structure pretty much throughout the world. My observation around that, among many other things, is that that doesn't in any way fly in the face of the capacity to risk manage at a local basis. So an institution such as Barclays will transact swaps in the United States currently through its main London legal entity. But that doesn't detract from the fact that the specialists in the dollar swaps market are those based in New York for the institution trading in that local market. The other thing that it doesn't frustrate in any way is the capacity to comply with local conduct of business rules as they are applied throughout the world. Operating on a universal bank model through the same legal entity doesn't in any way diminish the obligation on Barclays to comply with the MAS's conduct of business rules in Singapore, or those that might apply in Hong Kong, or quite frankly, any other market. So I just wanted to put that counter point in there, because there are obviously a lot of institutions that operate on that global model. Now, clearly, as a consequence of what we were describing before, the risk of subsidiarization, which derives from standards of conduct of business applying to, for example, a UK entity in respect of its global business, not just those that have the US connection, could cause that to change. But I wouldn't say that that's the case as it stands today.
Okay, I have Angie, then Marcelo, then Marcus, followed by Robert, and then we'll wrap up with Sarah and then turn to Brian's question. So, Angie, please.
Sure. Just following up on something that Chris and Stephen just said, we do see the direction of the market that Stephen highlighted, with the potential for localized, client-facing, and market risk-containing entities. But we don't like it very much. In particular, we don't like it because many of our clients don't like it. Some clients absolutely would like to face a U.S. entity for U.S. regulatory reasons. And when I say face, I mean have the U.S. entity being a booking entity. But for the most part, the very large internationally focused institutions would like to have all their risk in as few entities as possible. So one thing that we have thought about a lot when we think about how we conduct our business today is we fully recognize that under Dodd-Frank, you need a swap dealer or a securities-based swap dealer to interact with U.S. clients. But we think that if you look at something like the securities world today, we will have a fully regulated U.S. entity face U.S. clients, be responsible for all transactional requirements under Dodd-Frank, but then allow those transactions to be booked in the entity that they want it to be booked in, which is outside of the United States of America, and have the entity requirements for that booking entity be something that the CFTC and the SEC decide are of a comparable standard. So we think that model of having a fully regulated swap dealer or securities-based swap dealer in the United States that the SEC and the CFTC can look to meet and be responsible for all Dodd-Frank transactional requirements works. And it also allows our clients to have as much market risk as possible in, let's say, a foreign entity where they have a lot of other transactions.
Sorry, I need to interrupt you. So you were saying, the example, that entity A is the registrant.
Yes.
But entity B is the party that's actually the legal counterparty to a U.S. person.
Correct.
And therefore, don't regulate entity B?
You don't regulate entity B if you're satisfied that entity A is an affiliated entity and entity B's entity level requirements are of a comparable standard.
There is a mismatch, right? There's a mismatch because entity A is not the counterparty. So and the same point I'm going to make goes to branches of U.S. Of foreign banks. We cannot register a branch. A branch is not a legal person. Nobody's been able to convince me that a branch is a legal person. So we have to register the legal person. That's my thinking. I'm not binding the commission. But the example you gave, Angie, why are we doing it? Because we're not regulating the entity that is contracting with a U.S. counterparty.
you're regulating the entity that's on the hook for making sure that the transaction is cleared,
Right.
that the transaction is trade reported, that the transaction is traded on a U.S. regulated SEF.
Which is not accountable. Would you admit that the entity, what you're proposing is we do not regulate the entity that is the counterparty to the U.S. person?
Assuming that you're comfortable that that entity is regulated in a regulatory environment that you're comfortable with, and that you have some kind of information sharing and a way to get at it through the U.S. registrant.
Okay.
Angie, you're suggesting that in this situation where it's just a booking entity, it's not having any other type of interaction with the
Correct.
U.S. person.
Correct. I think there's two potential, for the client who wants to face the global non-U.S. entity, there's two options. All of the client contacts, all of the responsibility can be worn by that foreign entity, or alternatively, all of the client contact, all the responsibility for compliance with Dodd-Frank can come from a U.S. registered affiliate that's a swap dealer. In either model, both of them we think should be feasible under your rules, and both of them gives you the right to regulate a swap dealer or a securities-based swap dealer.
Marcelo.
I just wanted to add to Chris's point that, and a little bit to Angie's, we are not seeing this move that Stephen is seeing, and maybe that we are a universal bank. We're seeing, there was a little of that immediately post-Lehman. People were very concerned about the workout and all these types of issues, right? But what we are continuing to see is that people want to face the highest credit quality entity in the organization, and they want the benefits. Very few of our clients are not international. They're trading everywhere. They want the netting benefits, the offset of exposure benefits that you get by facing a single entity through a master agreement.
Marcus?
Just to repeat a couple things. One, this issue of deference versus delegation that came up before. You could certainly maintain your authority under Dodd-Frank over these entities and examine the regulations that these other regulated entities fell under and find that they satisfied Dodd-Frank requirements. That's a little different than completely than saying that you're going to permit a company that is not regulated under Dodd-Frank to transact with a U.S. person. But it could get to the same goals in terms of reducing duplication or extra bureaucracy. And I just also wanted to say something about this margin versus capital issue. The two are related, and the costs of margin drop when you take into account a good capital regime. But once again, they are not the same. One is a bottom-up approach to risk management. The other is a top-down. And I think that one of the goals of margining is to sort of build in from the bottom up in the system better habits of looking ahead to possible risks and managing possible risks from the moment that you start to sign up that transaction, to get people to think about the potential cost if the transaction goes south on them. And there are some other issues with potential capital arbitrage. Those are affected by Basel III, but I'm not completely sure that Basel III will seal all of those avenues. So, but that's another topic.
Okay, Robert, then Sarah, and then we'll see if Brian still has a question left.
When Dan asked his questions about affiliates, he was looking at me, so I wanted to be sure that I answered it. Let me give you a hypothetical. It's certainly simplified, but consider a FSA-regulated UK trading company that does not do business with does not do physical or financial business with any U.S. counterparty other than its U.S. affiliate. Now you have the U.S. affiliate, and it does no business outside the United States other than with its affiliates. All right? They're commonly owned. There's no systemic risk. So, what justifies all additional costs related to clearing and margining and all of the other administrative requirements? Further, if the CFTC takes jurisdiction over the UK entity, don't you expect the FSA will then take jurisdiction over the US entity? So I just question what benefits are.
Sarah?
Yeah, I was going back to Robert's question on the global entity concept and just talk from our perspective. I mean, Ideally, we would like a global booking entity construct. I mean, it's easier from a risk management perspective, less complicated for clients, and ultimately, I think easier for regulators if the risk is consolidated in one entity. I think, one of the things that there's a difference between where we are today and where we would like to be. I think one of the challenges here is that we need more mutual recognition amongst countries, because if you take, for example, Europe, in order to benefit from passporting in Europe, we have to book trades when we trade with the European counterparties in an EU affiliate. We can't have our US bank go into Europe. We'd have to go and get licenses. Now, I know that Europe was working on a sort of mutual recognition construct, and I think to the extent that regulators can work towards harmonised approaches and have mutual recognition, that will basically incentivise people to have harmonised regulation, and as well as allow entities like ourselves to potentially have a global booking entity that is based in the US where our parent is, and be able to trade around the world in those jurisdictions where there's mutual recognition. At the moment, we as an institution have to book our trades around lots of different companies around the world due to the local licensing requirements in those other regions. So it will help us a lot if the regulators work together to work towards some sort of mutual recognition.
Sarah, to put a fine point on that, that's not the case with your competitors in Europe who are able to book transactions with U.S. customers in Europe. Is that right?
You mean that they have, if they're set up in Europe, then they've already got an EU affiliate, but they don't. When they come on shore to the US, they don't have to use a US subsidiary.
That's right. In other words, you're not able, because you're based in the US, to run a single global booking entity, but a European-based entity would be able to, because it's really the passporting in Europe that's driving your need to be based in Europe as well as in the United States.
That is correct.
Brian, do you have a question left?
I actually want to see if I can bait somebody into a vociferous discussion with Ananda on the branch issue.
You have 5 minutes.
5 minutes. I guess, does anyone want to take a different view on whether we should be looking at registering branches? And I know there's authority under the definition to look at activities, lines of business, and call those entities dealers. And if we do, how do we deal with the capital and margin, or the capital margin and other entity level requirements when it's a branch as opposed to the whole entity? And this goes not only for example, your entity, Marcelo, having a New York branch, but also U.S.-based entities having branches in other countries.
Marcelo raised his flag before you even finished your question. And we'll take some other answers, and then I think Dan will get the last question. We'll try to do this quickly, given that we only have 5 minutes left. So, Marcelo, why don't you go first?
Okay, lamb to the slaughter, I guess. So the statute speaks to limited designation, and so it contemplates actually something much less juridical than even a branch. It contemplates divisions. So it contemplates an activity-based approach where God knows how you delineate the activity. On the other hand, when you have a branch, while it is, from a credit perspective, the same legal entity, and all those entity-wide rules will attach, it is also there's a well-understood perimeter around that branch, such that if the statute already allows someone to come to you and to register a division or something else, for them to come and say, hi, this is my New York branch, I want to register as a swap dealer because I've got a huge book already of swaps and I'm a dealer. I don't see why that would not be sufficient for your purposes when needing to ensure compliance. All the rules that attach to Deutsche Bank New York branch that are about capital, about prudential management, all of those rules are entity-level rules. And we're hoping that you find the German regime to be comparable and that, right? It's not that you're delegating and losing or assigning, you're just deferring. So I view it that way. And then for the transaction-based rules, you already have that because when the New York branch is speaking to a U.S. person or trading with a U.S. person, you have jurisdiction over all of that activity. It almost isn't a jurisdictional question. I mean,
Chris, why don't we let you go then, since we're trying to engage Ananda, see if he's got anything he wants to add to the point he made earlier, and as I said, we'll finish up with Dan. So, Chris?
Thank you. My point was going to be very similar to what Marcel has just articulated, which I think you have to ask the question, or one has to ask the question in conjunction with, going back to the first question of the panel, what is it that is the consequence of that registration? So on one level, logically, the notion of the registration of something which doesn't have distinct legal form is clearly quite conceptually challenging. But I think the question naturally segues quickly into, well, what does that mean? Where does that take you in terms of the conduct of business and or prudential regulations that might then apply? And to go back to the point which I made in answer to that first question on the panel, which is I don't think it's incompatible with that approach to say you would still, of course, as soon as you have the US nexus in terms of US person investor involvement, have all of the conduct of business rules applying to at a transaction level to what the firm based in London, for example, or elsewhere does. But that doesn't necessarily require you, notwithstanding that that entity is a registered swap dealer, to then extend conduct of business obligations to the business conducted between that entity in London and a counterpart or client that it has in France, Italy, or Spain, and so on. So I think my point is, I think you have to look at potentially the consequences of registration in conjunction with the notion of what it is that is the registrant.
Ananda, did you want to react?
I still can't get there because, and maybe I'm being too much of a lawyer. It's like, who is the legal person? Right? That's my first question. Who is the legal person? And the branch is not a legal person in the United States, right? Which means that it's the mothership which is the legal person. So as I said, that's where I go, or fathership, whatever it is. I go there and say, you must register. It's different if you, and then the second question is, where do I go, where does the CFTC send its staff to look for compliance? Now there maybe, we can go to the branch office and say, okay, it's like how we regulate BDFCMs, right? We know who to talk to look for compliance with the CFTC world, right? So that's what I'm thinking about. I just cannot get, this concept of registering a division. A division, to me, it's meaningless. It's not a legal person. So that's what my issue is.
Would it be helpful if I read the phrase? Because I think you're right completely and 1,000%. It says, a person may be designated a swap dealer for a single type or single class or category of swap activities and considered not to be a swap dealer for other types. So it's a person that gets registered, and what you're saying is that for a class of activity, they fulfill the swap dealer criteria, and for another class, they may not, so you may not require them to be a swap dealer for that other class, or you may. So it's a person, not a branch, and it's crystal clear, and I can't understand what's in a lot of the comment letters around this. So,
Wally, can't you read that to suggest you register the person, but it's only with respect to the activities in the branch? I'm not a lawyer, but
but it is a person. You're not registering a branch; you're registering a person, and you may limit the applicability of the registration requirements to a silo of activities.
So now I'm going to turn to the General Counsel of the CFTC for a legal answer.
Well, that was going to be the question, but it was basically the same. There's two aspects to the question. One is, can you have a branch, or can you have partial registration? And Wally's correctly read the statute on that. But then my question was the intent by doing that to not have the parent, not have the main company, which would be the booking agent, that they wouldn't register at all? We would just defer, or would it be they would also register, but then in our application of the requirements, we say, well, you're a registrant, but through comedy or deference or whatever, we would not apply. It wasn't clear to me that the other side of that was that the main booking entity would not be a registrant. I mean, or is that the goal? You want the branch to be the registrant and the main booking entity not to be the registrant at all? Or we would be okay to have the booking agent to be the registrant too, but the application not apply on the reasons of deference or whatever.
Angie, let me let Chris go first, and then I'll have you speak, okay? Go ahead, Chris.
I was going to say, I think you captured exactly what I think would have to be the approach, which is the notion that you can register something which doesn't have legal personality, of course, is very difficult to comprehend. What does that really mean? But I think the better question, which naturally flows, is, but what is the consequence of that registration? And is it a particular activity or series of activities which might, for example, be defined by reference to a more tightly defined US nexus, which then defines the consequences of that registration? And I think that's the two questions have to sit side by side. So the point I was trying to make just before, I think it's clearly from the point of view of who signs what piece of paper, it has to be the legal entity level.
Angie, it's your model that started all of this, so it may be
Yes.
appropriate for you to end.
It's my model, but I want to reiterate that my model doesn't involve branches. So this very interesting legal question is actually not something that I spent a lot of time on. However, if I think about dealing activity, if my foreign entity isn't interacting with U.S. clients at all, if there is always a registered U.S. swap dealer who is on the hook for every single requirement of Dodd-Frank, I'm not sure what the regulatory problem is with that. I see the counter side. I see that one could also require my foreign entity, because it's a booking entity, to register and then defer to all of the entity level requirements, defer to the foreign regulator, and at the U.S. level have all the transactional requirements. But I have to say it's challenging to have, even though we say deferral, it's challenging in practice to talk about an entity being regulated by two different parts of the world. And honestly, I haven't worked through it all, because it's hard enough to talk to the JFSA or the FSA about whether they would contemplate us registering that entity in the United States of America. But I think I see there's two approaches, but I do think that the regulators get what they need with a substantial intermediary in the United States of America who's registered, who's completely on the hook.
One thing I think needs to be added to the statement you've made, Angie, is that for a number of us, we live in a world where you do have dually regulated and dually registered entities, and we make it work. It can be made to work. That's not to say that the model you've put forward is not something that's worth considering, but I think it's not right to also come to the conclusion that it would be impossible to live in a world where you have an entity that is regulated by two regulators. And granted, they would have to work collaboratively, and you try to make things work as smoothly as possible. But it's not in the realm of the impossible. In fact, it's reality for us with respect to a number of entities. But I see that, Sarah, you've got your flag up, and we are about 5 minutes over. So you get the last word.
Well, I'm just looking at it from a different perspective, because we have our bank, but then we have foreign branches outside the US that we use to transact business, particularly in Asia. And, I think to your question, we would be registering the bank as a swaps dealer. And so then that bank would be subject to the entity level requirements of capital, prudential, other prudential requirements and credit risk management. I think the point that we'd like to make is in relation to that foreign branch's activities and the transactional level requirements only applying to transactions it does with US persons, not with its foreign clients. That's really the perspective that we're looking at it from.
Sarah, I was wrong. You don't get the last word. Chairman Gensler does, so let me get out of the way.
Mine's an easy one. I just wanted to thank all of you. I think this is the 14th roundtable we've had. No doubt we'll have more roundtables. We've had hundreds of meetings. I think we're approaching 1,000. I don't know which one of you has the lead on it, but somebody in the press will probably survey and say who's got more meetings. It's been an enormously beneficial I can speak for the CFTC and all of my commissioners. I think it's probably true for the SEC to have these roundtables. I know at the heart of many of your dealings is this international issue, which transactions are in, which entities are in, the branch issues and so forth. And I'm not here to address any of them. I'm just here listening, and it's very helpful. And I thank you. We're going to seek further public comment at the CFTC around these international issues. I think you kind of know the team here. Carl back here is our new team lead. I think the SEC can speak on how they're seeking further public comment. So you'll be able to look at a document and actually, get your lawyers and run up the, send us your legal briefs on it. But, this is enormously helpful. At the core, Dodd-Frank is about protecting the American public and promoting transparency in these markets and lowering risk. Hopefully that aligns with your interests. Sometimes it won't, and that's what the comment period's about. But I just want to thank you again.
Thank you, Chairman. We're going to break until 2:15 and resume at 2:15.
Well, I want to thank our third panel participants for participating today, and I'm going to do what we've done with all the other panels. If you could just go around the room and introduce yourselves and your organizations, that would be great. Kim, I caught you. You want to start and just introduce yourself and who you're with?
Kim Taylor, CME Clearing, and also CME Group.
Jonathan Short, Intercontinental Exchange.
Lee Oleski, TradeWeb.
Wally Turbeville, Better Markets.
Steve O'Connor, Morgan Stanley.
Pete Axelrod, DTCC.
James Coley, Javelin Capital Markets, also here for the SDMA.
Matthias Graulich, Eurex Clearing.
Iona Levine, LCH.
Varette Mims, Boeing.
Thank you. Our first panels this morning really addressed transactions and swap dealers and major swap participants, and this is our chance to learn more about global infrastructures, and by that we mean clearinghouses, repositories, exchanges, and potential CEFs. For the first question, I'm just going to turn it over to Ananda Radhakrishna to lead off.
Thank you, Jackie. As people know, Dodd-Frank has a clearing requirement, and I'll admit it took me quite a while to figure out what the requirement was. But basically, the requirement is that if the Commission determines that a particular type or class of swaps has to be cleared, in other words, mandated to be cleared, then certain types of people have to clear it, specifically swap dealers, major swap participants, and those people who come within the definition of a financial entity. And the requirement is that you clear it through a DCO that's registered with the Commission, or a clearinghouse that is exempted by the Commission from registration if there is a comparable regime. So, question is, as some of you may know, I personally am not in favor of giving anybody a break. So people have asked me, should we do this? And I said, my answer is, well, no, because we don't even know how this whole clearing thing is going to work out, right? Number one. Number two, we have right now 2 foreign-located clearinghouses who are DCOs, right? LCH and ICE Clear UK, and we have an application from CME Clearing Europe to be a DCO. So in other words, if you are a clearinghouse located outside, it's not difficult to become a DCO. It's not easy, but it's not difficult. But having said that, let's say that the Commission is determined to recognize foreign clearinghouses. How should we do that? What should we be looking to determine that a regime is comparable? And how should we tackle the specific issue of letting people know, or letting U.S. people know that if they do clear through a non-DCO, they do not get the segregation protections of the United States, nor do they get bankruptcy protection. So first question is, how do we go about determining comparability? And two, it's not a simple matter of giving somebody an exemption. Other things flow from it, right? Because clearing is not done in isolation. People have to clear through intermediaries, so other things flow from it. And you cannot represent that you are segregating funds pursuant to the CEA unless you're an FCM, right? And at the clearinghouse level, you cannot represent that unless you're a registered DCO. So if we give somebody an exemption, how do we tell the whole world, something goes wrong, don't come looking at me? That's basically what my question is.
I noticed that Ananda's drinking Bob Marley's Mellow Mood. I don't know if one of you gave that to him, but it hasn't affected him yet. So we're going to let him keep going until that sets in. So I'm looking at the clearinghouses specifically because this seemed to be a clearinghouse question. So I'm looking at Iona or Kim or Jonathan, or any of you want to take the first hit at tackling Ananda's question?
I'll jump in and just start us off, Jackie. Jonathan Short with Intercontinental Exchange. We are one of the clearinghouses that Ananda mentioned. We do have a foreign clearinghouse, a recognized clearinghouse in London, ICE Clear Europe, that is also a DCO. So I acknowledge what Ananda said. It is possible to become a DCO and still have your primary regulatory status in your home jurisdiction. That said, I think where the challenge comes in that would probably tip me in favor of some sort of exemptive and mutual recognition regime is that if you play that out across all of the jurisdictions that might have an interest here, when you take into account where Europe may be going in its regulation, things can get a lot more complicated. You may be talking about more than being a recognized clearinghouse and a DCO. You may have other iterations that you have to comply with, and I think that some sort of mutual recognition or exemptive relief is appropriate. I do also think that Ananda is right in that I think there are some assumptions that people make about the protections that you get from being a DCO. I personally think that should be addressed through disclosure. I mean, if you have consenting parties that understand the insolvency and bankruptcy regimes of the country in question and the rules, they should be permitted to have their positions in clearinghouses that may not provide the last level of protection that a DCO might provide.
I would agree with what Jonathan's talking about a mutual recognition regime having some significant benefits because there could be multi-jurisdictional impact, and every time an entity is required to directly adhere to even slightly different sets of regulatory requirements, it becomes a complication. Certainly it can be done, but it becomes a complication. And one aspect that I would hold out as a potential model would be what the UK has done for a number of years with its recognized overseas clearinghouse and recognized overseas investment exchange programs. CME has both of those statuses for our U.S. entities, and they were both highly reliant on the FSA satisfying themselves that our home country regime was comparable enough with the regime in the UK that they allowed us to operate in their jurisdiction with the same kind of bankruptcy protection as a local clearinghouse, but without having to explicitly meet all of their express requirements. And it seems like something like that would be a model for the regulators to work collectively toward in the future. It would have been preferable from our point of view if that would have extended beyond the UK into other parts of the European Union. So something that would be broader, I think, would be more preferable.
I think the answer might be slightly more complicated than that. We're a DCO, and obviously we're sort of in the UK as well, and we haven't to date found any problems at all whatsoever with the current system. Now, we feel incredibly comfortable with the current system, and I think perhaps this will come out of a question slightly later on, where could it go wrong? And whilst we're completely comfortable with the current system, what we're worried about going forward, and I don't want to go into details now because I'm sure it is another question, is any sort of inconsistencies between the sort of number of regimes that you have to actually comply with. And I can see very good reasons why one would want to continue to be a DCO here, if in fact one was offering client clearing. And perhaps the trick is to look at this slightly differently. The trick is to say, what is it that's being cleared? Is it just interbank clearing? And if you're doing a minute amount of interbank clearing, do you need to be really regulated? Or is it in fact customer clearing that you're looking at. And so we took a decision that basically we want to be able to give US customers US protections. We didn't want there to be any confusion about this. So we've completely embraced the whole sort of US client segregation, and we think that that's very good. What we don't want to be banned from doing, though, is to be able to offer different kinds of segregation in different jurisdictions. And this probably comes on to something slightly later. So, for example, if one kind of client protection was available in Europe, we'd want to be able to offer that to European clients. If the Japanese decided to do something different for their clients, we want to be able to offer that. And we want to also be able to offer US client segregation in the way in which the US finally determines that they want to do it.
Well, from my perspective, recognition of foreign clearinghouses is a very important aspect. And I'm not looking only at the relationship between the US and Europe, as Eurex is Europe domiciled. I mean, if you look at the G20, so we're talking about 20 countries all or setting up their rules. If you now look and look at the US approach, that you say a US a transaction involving a US client needs to be cleared by DCO. If the Japanese say, well, if a Japanese client is to be cleared by a clearinghouse registered in Japan, and if you go around the world, we as a clearinghouse are regulated by 15, 20 regulators globally. I don't say that it's not possible, but it is very inefficient. And if you look, there are already rules existing, like the CPS IOSCO recommendations for CCPs, which are of global nature. So I think we need to have a international recognition framework based on, for example, the CPS IOSCO recommendations to allow clearinghouses a simplified process to be recognized in foreign countries, and also from an auditing perspective that, well, the practices of the local regulator are to some degree acknowledged by the foreign regulatory authorities.
Well, as a non-clearinghouse user, I think the one thing you have to keep in mind is netting agreements, in the sense that if we don't have mutual agreements out there, what will happen is I may have to increase the amount of collateral I'm going to put up, because I'm not, if a foreign clearinghouse isn't recognizing a U.S.-based, subsidiary outside the country, then I have to put up even more money. And so right now, as I agree with them, it's relatively efficient if people are having to clear in Japan and Australia. But I think part of the problem is you can't say to yourself, for a U.S. corporate, most of them are used to netting out those transactions. And if they have multiple exchanges now with multiple regulations, then it's going to be really difficult. To their point, not impossible, but more difficult and more costly.
I'm going to allow Nana just to follow up on his question if he has it, and then I have a follow-up as well.
So I think Matthias is suggesting that what we could do, if we went down this route, was to look at compliance with the CPS IOSCO standards, because that, as all of you know, the Dodd-Frank Act basically codified the current version of the CPS IOSCO standards. And in our rulemakings, we're trying to be as consistent with the latest draft, which is now out for public consultation. But the other question I want to ask is, should the Commission condition it on reciprocity, number one? And number two, can we do it legally given the number of trade agreements that we've signed, the United States has signed? So, because it'd be rather unfortunate if the CFTC and or the SEC were the only two regulators who had such a program and nobody else did.
By the way, if you want to speak, please put up your placard and then I can call you in order. But I see Kim wants to say something, so go ahead.
Personally, I think from our point of view, the reciprocity, the mutuality of the arrangement would be important, because I think we would want to be able to be assured that if competitors were able to easily enter our jurisdiction, that we would be equally easy able to enter other jurisdictions. So I think that that would be an important feature. I think, though, it's perhaps a little bit off the topic of your original question, but I think one of the points that Matthias was making was I think very important and is actually an aspect of the whole thing that I think produces an extra layer of complexity, and that is the tendency that is being shown right now in the rulemaking at various stages in various places of requiring that certain types of parties have to clear in certain places. And I think that particularly in the over-the-counter swaps arena, the customers have a certain level of sophistication just by being able to be participants in that market. And I think that it is creating an artificial set of requirements to require certain types of transactions by certain types of parties to clear in certain jurisdictions. So that would be something that I would also encourage us to think long and hard about doing.
Wally?
The couple things to keep in mind is that it will be a new world, and clearing as a concept is become really central to the Dodd-Frank structure. And along with that, I think people's faith in clearing is heightened as well. And clearing can be thought of as a panacea for many kinds of risks. And so the concern is that while certainly operationally to make things as efficient as possible, the notion of substantive inquiry into the not only the rules but the performance under the rules and the level of enforcement by regulators in another jurisdiction is quite important. One of the things that we get concerned about is the potential for the interconnectedness of clearing, and how you could imagine a situation where a clearinghouse might run into trouble, and that could infect other clearinghouses and the faith in other clearinghouses, which would be problematic. So, the point being, in substance, there really does have to be a certain level of meaning to what clearing is, and certain basic standards have to be fulfilled, and certainly disclosures have to be complete. So that's. I think we do look at the situation now as being, with clearing so much more pervasive, the whole question of interconnectedness is very, very important in making sure certain standards are maintained.
One last comment on this, James.
Javelin is an electronic swaps execution venue that expects to file as a SEF once the rules have been finalized. For us, and one of the key things you got to look at when it comes to foreign entities trading here or clearing here is that they comply with all the provisions of the Act. And where we sit specifically, we focus a lot in our interaction with clearinghouses, especially when it comes to access, and that they allow SEFs to connect in and to launch all in the same day. And we haven't seen that. We've seen it from the CME. We're negotiating with ICE right now. And frankly, not to put anyone on the spot, but LCH told us that they're going to launch with Bloomberg and Tradeweb before they launch with us. So, these are the issues that we focus on, is if you're going to open for business on one day, let's all open on the same day, and let's not show favoritism to one execution venue or the other. I thought I might kick off with that.
Guys, I'm not really...
Before this just shifts into an access, why don't Iona have a chance to go back to James about this comment, and then we'll continue on some of the clearing questions. Go ahead, Iona.
Okay, I'm not sure this is quite the right forum to sort of say who said what to who and whose email was whatever. Anyway, look, what I would say is that a clearinghouse would be crazy not to want to have every SEF that was operationally, and I won't use the word competent as sort of a slur on anybody, I just say the word competent as a sort of a base level, assuming that it is, and not making any sort of aspersions to anybody, we would want everybody to connect to us. We think that everybody should be mandated to connect to us because that's where we get our business from. I cannot speak to why people are having some sort of sideways spat on who is the first one that could test. We're not talking about connecting. We're talking about running a pilot program with an API. And I cannot believe that a clearinghouse can be mandated to run a pilot program with absolutely everybody on the planet to see if they can connect first off. I think that Dodd-Frank is not trying to micromanage everybody to say that, in fact, LCH has to allow, 20 CEFs, 30 CEFs, some of whom are not ready, some of whom are ready to test something. LCH simply doesn't have the resources, nor does anybody. You should be able to test with one or two that seem readier, provided that when the day comes, you've tested with them and your API is open to everybody. I think you'll go back and find that that's the subject of the emails. But look, I think this is enough of a spat.
If I may respond.
Wait. One last response.
Okay.
And then we might come back as we address some CEF and open access issues. But this is.
So we don't see these issues with domestic clearinghouses. We've connected into the CME for months, and we've been operationally ready there for months. We do have issue with foreign entities that come in and expect to do business in this country and look for reasons to circumvent some of the issues. So not to put LCH on the spot, but the practical reality is that we've been waiting to connect in for months now, and it shouldn't take us 2 months to negotiate an NDA.
It's very interesting. Before I came here, I said, I've never sat on one of these panels. I said, what's it like? Is it like, in the Roman amphitheatre where they throw you to the lions if you get the answers wrong? And I was assured, no, it's far more charming than that. And people are just interested in the answers.
We just let the lions eat each other.
Absolutely. Somebody wrongly briefed me. Listen, one, I take real exception to being called a foreign entity, okay, because I'm not a foreign entity. I'm a DCO, okay. I don't like being called a foreign entity. But apart from that, why don't we go and have a coffee and sort this out?
Fair enough.
Okay, good. Well, if we keep having more of those, you've kind of let the moderators off the hook with conversations. But Wally, did you want to say something on this issue or something new?
Sort of new. In terms of making this a teaching moment, I guess what we've discovered here, I didn't get any of the emails, so I don't remember. But what we've discovered here is that there are other issues, right? Which not only is Dodd-Frank about creditworthiness and making sure there are standards, there are also access issues. So I think the significant point here is that that the whole notion of looking to exemption and looking to other ways to broaden different forms of the infrastructure and how they all work, those sorts of issues are, unfortunately, I think, sounds like they're sort of in your court as well, is not just pure credit, but other kinds of issues that are reflective of what Dodd-Frank wants to achieve in terms of a market structure.
I want to pick up on this thought of recognition because it's something that none of the panelists have mentioned yet. It came up earlier. But regarding clearinghouses and CEFs, where we do have the ability to recognize, right now there is nothing to recognize to. There's no law in place in other parts of the world. So what do the panelists suggest regarding this timing issue?
Well, I think we have to distinguish. I mean, if we look at, for example, CEFs or trade repositories, this is pretty new to the marketplace. And rules are drafted all around the world now. If we talk about clearinghouses have been around for many years. There is regulatory oversight for many clearinghouses around the globe since many years. There are standard rules. So, and I think these standard rules are all around proper margin regimes, risk models, stress testing, back testing, access requirements. So all these rules are there since many years. So I think even the fact that the swaps regulation or the clearing obligation is in different stages around the world, shouldn't be an argument to say we have to wait until everything in this particular area is ready, because clearing houses are there and clearing houses have their regime and everything. So I think that should be taken into consideration, as it is little different to other elements of this new world.
Pete and then Lee.
I was just going to make a general comment that I've now lost my train of thought, but why don't we go Lee and then Pete?
Lee, you ready?
Yes, thanks. I think the question is, what do we do in this interim period before the rules are exactly clear? I can't speak for clearing corps. I can speak for electronic trading venues and hopefully those that intend to become CEFs. We've been in the business of trading electronically for 12 years. We've traded derivative instruments for 5 years. We trade 250 to 300 billion per day among institutions around the world, with 50 banks and 2,000 institutions and all the world's central banks. Given that, I guess the message I would like to send is, I think we should be encouraging more activity to happen on electronic venues that afford all of the policy objectives that Dodd-Frank was about, in terms of enhanced transparency, easier access, more efficient markets, and a safer environment. So in this interim period, while you have businesses that have taken advantage of technology over the last 12 to 15 years and started to connect people up electronically, and it's not just TradeWeb, there's plenty of others, Bloomberg, et cetera, I think we should be encouraging that kind of activity because it's ultimately serving the same policy objectives that the law was set out to do. And not to discourage that kind of activity. I think the good news is, I can speak for TradeWeb, and I'm sure it's the same with plenty of other market participants, our derivative activity has more than doubled in the last year. Very simply put, they're doing it, the customers are doing it, the institutions and dealers, with an expectation of rules that will come into play, and they're preparing themselves for it. And they're preparing for this new environment, which, by the way, they would have been doing anyhow, and they have been doing for the last 12 to 15 years. It's just going to happen at a faster pace now. So I would say anything that kind of encourages more of that activity is a good thing from a policy standpoint. Obviously, we're very interested in seeing what the final rules are and developing the technology and the response to the rules so that we meet all of the criteria. And the sooner that happens, the better from our perspective. But in this interim period, I think we should be encouraging all market participants to be following this path that's been laid out within the law, which is transparency. It's not per se electronic trading, but transparency, greater efficiency, capturing data, which allows for, a better review of the marketplace in times of stress.
On the question on recognition and
okay.
timing, Pete?
Yeah, okay. I've remembered now. Essentially everybody is sort of addressing the recognition issue as, there are a lot of jurisdictions who are interested in what I do, so who's going to be the regulator? We've operated for many years with multiple regulators, some of our entities, and I can guarantee you that most of the trade repositories that are going to apply for registration as an SDR are going to carry another regulator with them for one reason or another. If we've got a regulated repository, a supervised repository today that's based in New York, is primarily supervised by the Federal Reserve Bank of New York and the New York State Banking Department. We've got another one in London that is primarily supervised by the FSA. I guess I've got a question for the panel. It is quite likely that these are the entities we are going to come in and try to register as SDRs. And so are you going to make us shed our current regulation? Are you happy to regulate with these people? How is this going to work?
I don't think we can tell another regulator to just leave because we have an interest. So I don't think that's our right. We can express an interest and regulate you, but we can't force somebody else to get out of your business if they require you to also be registered. So I don't know if that was your question, but that's...
I guess it sounds like you're happy to live in a world where there are multiple supervisors of the same infrastructure.
I think what we said earlier is we recognize that there are issues, and that's why we're trying to coordinate to the maximum extent possible so that we don't create sort of multiple conflicts for you. But in the situation where we are going to regulate, I think we can work with the other regulator as well. And you already said you're regulated by multiple people as it is, and
we
you're
don't,
still around.
Yeah, as opposed to others, I guess repositories are a little different. We don't mind having many regulators because, in effect, the world works like that today. We're responsible to many regulators.
Jackie, I'm one of the regulators of DTCC affiliates, and we actually find that it helps to have multiple perspectives brought to bear on important infrastructures like clearinghouses. So we regulate with the Fed and with the New York State Banking Authority, and we find that to be actually helpful. Market regulators bring different perspectives to the table as opposed to prudential regulators. We think it's a good combination. So we have experience with it, and we're going to have a lot more in the new Dodd-Frank world.
Kim?
I was going to speak to the recognition issues. Do you still want to talk about that or
Please,
not?
yes.
Okay. I guess I would suggest, I would agree with, I think it was Matthias that said you don't really need to have the regulations fully in place in other places in order to have recognition. I would suggest that probably you already have a number of things where you have agreements with other regulators about, you already have a sense of where you've got comparability of regimes, and I would suggest that maybe you use that as a baseline. Certainly with over-the-counter swaps, you would need to make sure that there is a kind of a legal enforceability of a cleared transaction in that product set in the jurisdiction. And beyond that, a lot of the things would be just the same basic things that you would look at in evaluating any clearinghouse: risk management, bankruptcy clarity, customer protection. Is there disclosure? I don't think it would be necessary that the regs would be fully implemented in other jurisdictions before you would be able to do it.
Lee?
Yeah, I agree with that, and I mean I can only sort of speak for the CEF side of the world, but I think it's a situation where if you think they're heading in the same with the same policy objectives and the same sort of critical things as it relates to the execution side, are these going to be regulated entities? As you said, is this going to be required to be cleared centrally? Is there going to be the same transparency elements that we expect to see out of Dodd-Frank? Is there going to be a central repository? I think if you check on those 4 or 5 key points and you see that's the direction, that's the right answer. And then ultimately, in terms of once the rules are out on all sides of the Atlantic, then you can make determinations in terms of reciprocity or exemptive decisions for customers to do business, as you've done with futures exchanges and other types of entities.
Jonathan and then Ethiopis.
I just wanted to go back to swap data repositories for a moment and talk about what we found to be one interesting part of that statute, and that is the obligation of an SDR to obtain an indemnity from a foreign regulator if you're going to share information. I never understood why that was in the statute, and I scratch my head as to how I'm going to approach the foreign regulator and ask for an indemnity, which I can pretty much guarantee you what the response is going to be. But does that suggest that we're going to be SDRs that are regulated everywhere, and that's the way we get around this indemnity issue? We share the information with them directly, and it's everybody's information?
The CFTC and SEC have been working on this issue. We know it's problematic. We know it is not the goal to keep information from regulators that need it. So we recognize the issue that the indemnity clause brings. That said, I think there are a couple of ways for regulators to get the information, foreign regulators. One is through the normal channels, which is through the regulator. And so if the CFTC or SEC directly regulates the repository and the foreign regulator needs the information, they can come to us for an express regulatory purpose and get the information. And then second, if separately regulated by that foreign regulator in their own right, they can access the information without the indemnity. Pete, did you want to say something on that?
Well, since we all know that the indemnity provision is an issue, I very much like the idea that if there are multiple regulators, each regulator gets to see it without an indemnity. So I guess I would urge the commissions, if I know you've got your own lawyers, but if you can see your way clear to a solution like that, I think it would make everybody happy. The other thing is, of course, that we've had a lot of discussions with regulators that wanted access to the data we currently have, and it was fairly clear, as it would be to the U.S. regulators, that nobody wants to have to ask another regulator for the data. Right now, there are 30 regulators around the world that have automatic sort of online access to our data. They like that. That means they don't have to ask. People don't have to know what they're investigating, all that sort of thing. So I'm hoping that we can get towards a conclusion that doesn't require one regulator asking permission of anybody to get data that today they can get without asking permission.
Thank you, Kim.
So we seem to have moved on to the SDR topic on our own. So
it's running away from us. So go ahead.
One of the aspects of the SDR topic that I wanted to be sure that we talked about was the sense that I have that clearinghouses are going to function as natural SDRs for the transactions that they clear, and I think that it will be fairly quickly if clearing adoption goes, according to the mandate certainly, or if there are mandates that emerge in other jurisdictions as well. I think very soon there will be an abundance of transactions that are cleared, and I think that I would caution us from developing a market structure that requires that an additional third party be a part of every transaction, because I think at some point, once clearing is adopted, it will become almost an unnecessary additional cost and operational burden for all cleared transactions to be reported also to another third party. And what I'm wondering is if there's an opportunity to use as a somewhat of a model the CFTC's large trader reporting system, which allows a regulator to take a standard format, input format from a variety of different sources. Think of it as a variety of SDRs in this case, as opposed to a variety of markets, and accumulate that information and be able to use it either on a routine basis for its own purposes or use it on an ad hoc basis for its own purposes. I'm somewhat concerned about creating a market structure that requires kind of duplicative reporting of all transactions. Certainly the uncleared transactions, not all clearinghouses may decide to become an SDR for those transactions if that's allowed. I think there's a little bit of a gray area there, but I would encourage us not to create an infrastructure that requires duplicative processing of all the cleared transactions.
Pete?
Yeah, I guess I would take very strong issue with Kim's characterization of duplicative reporting. In fact, that is the structure Kim is suggesting is likely to end up with inaccurate reporting to the regulators and difficulty for the market participants who have the ultimate reporting obligation under Dodd-Frank. As you heard this morning, the market participants, the ones with the ultimate reporting obligation, really want one point of control. Not that there has to be one repository, but they want to pick one place as a point of control for their reporting obligations. And to relate this back to international provisions, most of these firms will have reporting obligations in multiple jurisdictions that they have to manage. The only way the firms that I've talked with have seen to be able to manage these reporting obligations is to have a single point of control. And if they so choose to have a single repository for reporting of all of their transactions, it doesn't seem to me that the regulators should mandate otherwise, because that's the way they think they can best control the information flowing in. Furthermore, I guess I would say that it doesn't have to be duplicative reporting if the DCOs would report to the repositories at the request of our mutual clients.
So what if it transpired that in order for a DCO to be an SDR, it must also accept reports on uncleared transactions? Were you suggesting, Kim, that you would only be the SDR for clear transactions, or would you be willing to do uncleared? Or if the commission said you got to do both, would you be willing to do both?
If it turned out that we had to do both, my expectation is that we probably would, if we found that our clients valued that service. I think my point really was that clearinghouse is a natural automatic SDR for the transactions that it clears, and for those transactions, I would hate for there to be a mandate, a regulatory mandate, that there also be reported somewhere else. If the clients choose to, I'm not suggesting that there be a mandate that the clients aren't allowed to report their transactions someplace else. I'm just suggesting that there should not be a mandate that requires clients to use an additional service that I think over time will end up being more duplicative than not.
But then if you or ICE or LCH say, look, we want to be an SDR, and if people choose to report uncleared transactions to us, we'll be happy to accept them. You guys would, that's fine with you guys?
I mean, I can't speak for ICE or LCH, but certainly that would be something that we would consider doing.
For ICE, yes.
Yes, we would as well.
So what do the SDRs, what do the CEFs think about this? Those of you who may want to be CEFs.
From the CEF standpoint, I think, well, Kim is certainly correct. I think it's a good idea that you don't want to have unnecessary duplication throughout the system. And today, where there's not a lot of transparency in prices, we crave this reporting function. I think over time, the importance of it's going to decay over time. As the market becomes more and more transparent.
Sorry, the importance of what is going to do?
Of the information in terms of the hunger for the information. Because right now we don't have that information, but it should become fairly ubiquitous if this thing works, right? So from the CEF standpoint, CEFs, under the rules that you've written, are also required to report trades. And from where we sit from Javelin, we are certainly willing to work with clearinghouses and also in terms of reporting that information, because we're the point of execution. Likewise, we're also happy to pick up information on trades that haven't been executed on our platform. So it's a catch-all, because if we have that plumbing to be it CCPs or indeed regulators, we should be able to use it and profit from it to collect other data and to make that data more valuable both to regulators and to the market as a whole.
Ethiopius, did you want to interject something here?
Stir things up a little bit maybe and play devil's advocate vis-a-vis what Kim was saying. Don't we run the risk without mandating a central third-party location for the data that will get data fragmentation? Data fragmentation that's not in the interest of systemic risk management or risk management generally.
I mean, what I would suggest is that if a party decided that they were going to SDR their cleared trades wherever they cleared them, and SDR their uncleared trades wherever they chose, could be one of the clearinghouses they participate in, could be a separate third party, that there would not be. The parties would need to make sure that they are not duplicate reporting. I agree with that. But then all you need is a standard kind of mechanism for regulators or interested parties to be able to pull data out, or for the entities acting as SDRs to be able to deliver data to that central repository. And I know that a mechanism like this, this can work, because I really think it is very similar to the type of mechanism that the CFTC has long had in place with reporting of the large trader positions. They're reported by the individual market participants, and actually their dealers tend to report them for them, reported to different markets who then pass through the information in a standard format to the CFTC. So the markets get to use the same information for market surveillance. It's passed through to the CFTC for its own market surveillance and its own risk management across the broad industry. And it's done very effectively on a daily basis with a single reporting act and a single reporting format by market participants. So it's very efficient.
But if my recollection serves, there's no public dissemination of that, right? I mean, this is not consolidated information.
Well, it's aggregated at the end by the CFTC at the end of the week. I mean, I think one thing I was just going to follow on what Ethiopis was saying is that I think the burden shifts. The burden then is on the regulator to sort of aggregate and assess, rather than what the goal was from the repositories, I think, was somebody who would just shovel this aggregated information in whatever form to the regulator. I mean, I think it just shifts the burden, perhaps, is what you're talking about.
If I can...
Let's go in order. Let's see. I think you all had a... Go ahead, Lee.
I just wanted to respond to Ananda's question about what the CEFs would think about it, and then get to your 2 points. I think there's two different policy goals out of what we're talking about. One is to give the regulators a place to go to where they can look at a view of the market in a consolidated way and assess what's happening. And that is a unique goal that's not necessarily a transparency goal per se, but a observing the market goal. And I think that is best served by things being in one place, given the complexity of these markets. Aggregating it from a bunch of different places, I'm sure it can be accomplished, but I think there are some questions about how that would all come together. And technically, anything can be done. That can be done. The question is, what does it look like? And I think it does shift the burden to the regulators to really then have that element under control, which is this aggregation. The second objective, I think, out of these these types of entities is transparency, which is price transparency to the public. And that's one where I think competition is a good thing. I think it's a good thing to allow anyone to do this, to allow anyone to commercialize this data, and more importantly, to have a requirement to get the data out, which is part of the whole rule set, to get it out within a specific period of time. And I think once it's out in the public environment, there's going to be all sorts of commercial interests that are going to come in and try and aggregate that information, capture that information, disseminate that information, and make it commercially viable and acceptable and usable by the marketplace. So I think there are two different objectives in my mind between these two things, and the one that would concern me is, given the complexity of the derivative markets and the number of different instruments, to put that on the shoulders of the regulators to re-aggregate so that it works, I think would be a challenge across all asset classes. I mean, it gets complicated.
I don't know who's first, but Steve and then Wally.
Yes, I think I would agree with Lee there. I think it's important to make the distinction between public reporting and regulatory reporting, and I think the SDRs are the regulatory reporting. And I imagine that SDR is a giant spreadsheet that allows you guys to sort by any column that you want to pick up the next AIG or long-term capital or whatever, and to have a system where you have multiple versions of that spreadsheet that need to be aggregated. It presents an enormous challenge, I think.
I believe that fragmentation is the issue, not duplicative reporting, and I think fragmentation is potentially a behemoth issue. And the concern is that there'll be an electronic swap data Tower of Babel running around, and any one sort of silo of the information is potentially volatile and damaging in itself. In other words, the only way to truly understand the market is to understand the market and the relationships between all of these things. There would be a great burden on the regulators at this point. We had hoped months ago that the regulators would have the capacity in terms of budget and all the rest to actually do the proper aggregation of the data and make sense of it. That may or may not be the case now. But one thing that we have stressed in our comment letters relating to SDRs, is that as SDRs are registered, that a part of that is one way to make the data more usable and more aggregatable is if all of the information as it comes from the SDR is in a format and style that allows you to do that more easily. So, right, instead of having multiple spreadsheets that somehow have to get pushed together, to have some kind of a standardized language as it comes from the SDR. In other words, they're writing to your API as opposed to you having to take down all of the different forms of language and make it a common language.
Yeah, so then you're into the SDR of SDRs, which itself is a new a new behemoth that I don't think you guys should be running.
Understood. Who is next? Matthias?
Well, perhaps I'm mistaken, but there is no requirement for one global TR, right? So there will be multiple TRs globally and also under your jurisdiction. So the effort for the regulators to aggregate information will be there in any way. So the key question is, what I think would simplify this whole process is that there is a standardized format, making it much easier for the regulator to collect the data and aggregate the data from the different trade repositories. Therefore, and I agree with what Kim said, I wouldn't see a big additional effort if clearinghouses would act also as a trade repository for clear transactions, because it is the natural home. All information is there. So it's just unnecessary and avoid duplicative work if it is additionally transmitted to a trade repository where the same data is then made available. So
okay,
yeah,
go ahead.
I would say that one of the things you have to remember is that the Act didn't contemplate one SDR. It contemplated many STRs, and in that is the tension of fragmentation, or the risk of fragmentation. So unfortunately, that's something we all have to live with, especially you. The reality, though, is that there are already repositories for trades naturally at clearinghouses, and also as they occur on execution venues, that they be captured there. It's not necessarily, as Wally would suggest, a Tower of Babel situation if managed correctly. It's very easy to take, and I would hope that any SDR doesn't use necessarily a spreadsheet or a fax machine these days, but indeed use a commonly accepted protocol and API infrastructure through which this data could be collected. So whether it come from CEFs or come from CCPs, it's not that difficult to aggregate it such that the data doesn't fall through the cracks.
Pete?
I guess I just wanted to double check something, because it sounded like Kim and I ended up being in violent agreement about something, and I also wanted to respond to James. I do think, we spent over $100 million on inventory control, among other things. I think it is more difficult than people might first imagine if they haven't tried to do it, to aggregate correctly. But I'm quite happy, and I think it's DTCC's position, that the market should and probably will work itself out on this. At this point, we've had a lot of discussions. It seems to be relatively clear that the consensus view of the regulators, both here and abroad, is that they're not going to mandate a single repository. I do think, though, that it sounds, if it's up to the users, the people with the reporting obligations to choose, so be it. I just want to make sure that the playing field is level and that there's no sort of vertical bundling of services that amounts to some sort of, unfair trade practices. But as long as the playing field is level, I think the users themselves, or the market participants themselves, will work it out, and you'll end up with what you end up with.
And I think I need to say I was playing devil's advocate, and I think it's clear that the
the statute doesn't call for us placing our finger on the scale in favor of a single point of reporting. But by the same token, I don't think it also calls for us to put our finger on the scale in the favor of reporting through a clearing agency. And as I think Pete is saying, if that ends up being the choice of the participants, so be it. But I don't think we should be in the business of putting our finger on the scale one way or the other.
Fair.
So as a corporation, I think the one thing to keep in mind when we're talking about these SDRs is the notion that we have an end-user exemption. But in the sense like our capital corporation may not, and now they're a reporting entity, and so we're saying we don't have a single standard. I mean, for some corporations we use SWIFT, but we're not a member of SWIFT at Boeing, and a lot of other big corporations aren't. So in terms of having the standard language now, you know, we still have a budgeting process as well that says, okay, how do I budget for being in compliance with these regs? Since I don't know what SCFs are going to be accepted, of course, as a corporate, we want more than less. And still, I'd have to budget for which SCF because we've used TradeWeb in the past, and it costs money. And so at the end of the day, it's like, if we have more than 20 or however many we're going to have, I think for a corporation is this notion that more is better. But back to this notion of cleared versus uncleared, because we know that the regs are going to say margin requirements much higher for uncleared swaps. I'll give you an example. So at BCC, if they wanted to do, that's our capital corp, if they wanted to do one single swap to swap out their fixed rate debt to floating, they could do one swap and do like $500 million in one swap. And so now that I have to now do a cleared trade, I may have to do 500 different transactions and do them more frequently. So now I have that additional transaction cost. Now I have the additional transaction cost of now reporting that trade if I am the reporting entity, which they would be. So I think the one thing to keep in mind for us, it just becomes more and more additive in terms of cost versus the way OTC is so customized now, where we pick up the phone, call a bank, shop the trade, hang up the phone, and confirm it. So I just think we have to keep all these things in mind when we're setting up these structures for the end user, because you guys being the, you already have, as you say, the natural thing is for clearinghouses do have all these systems set up. Corporations do not. So I just want everybody to keep that in mind when we're setting up the market infrastructure.
Dan?
I was just going to add my recollections from the debate on the legislation when this issue was debated in the legislation. Should we have one SDR or multiple SDRs? And what Ethiopis was saying, as I recall it, the sentiment in the Congress, and certainly in this agency was participating in the legislative process, the feeling was people were reluctant to decide, we determine there shall be one SDR, or we shall determine how many SDRs there shall be. It's let's let the market decide how many SDRs there shall be. Clearly, it contemplates that there might not be an SDR for a particular type of swaps, in which case the Commission is directed to essentially perform that function. I'd also note that there's also a difference when we're talking about whether there are multiple SDRs for the same class of swaps, or there's multiple SDRs for different classes of swaps. And I think then again, we'll see what the market brings in terms of consolidation of multiple classes of swaps in a single SDR, or we're going to have multiple SDRs based upon different classes of swaps. But I think the legislation clearly contemplated the marketplace would decide, and then the Commission would have some type of rule for what the market's not covering.
Lee, did you have another point? Sure.
Just a quick follow-up. I wanted to follow up on both those points. I think, very important to have flexibility here and a competitive environment among different participants, because I think that's how, clients will be best served, whether they're institutional clients or, frankly, we, in some respects, will think of us as a CEF, but we're, in a sense, a client of the clearing corps and other entities that are participating in this space. So we want to see flexibility. We want to see a number of different competitors, because we think that's the way you get the best product and the best service and the best pricing. But I guess the last thing I wanted to add is we need certainty of timing too, because I think that the cost associated with the uncertainty that continues to go on from month to month and year to year is going to start to have an impact on the willingness of entities to invest capital in different spaces. So I can speak for my company, TradeWeb. where we invest a lot in R&D, we're spending a lot on technology, and the longer it goes not knowing precisely what the rules are, the harder and harder it gets. And I've got a board meeting this week to go in and explain to my shareholders why we're going to spend on, a technology that supports a certain type of trading model, when the impact is actually going to occur, when we have an opportunity to make profits on those investments. And I think the longer the process goes on, the more uncertainty there is over the months. I think it's likely to push out certain people who would invest in this space, and it's not going to be us because we're in it for the long haul. But I think it's a cost. It's a cost to our clients in terms of figuring out how to get set up to deal in this new environment. And I think that it's not just a question of the fear that things will leave the U.S. jurisdiction and go to other jurisdictions. I think there's also a fear that it will just slow down innovation and investment, and that's obviously not a good thing to be doing right now. I think we want to get through these rules as quickly as possible so people can start to invest and develop and deploy.
Thanks. Brian?
I wanted to kind of shift the topic a little bit, stay on SDR, but address another aspect of it, the international situation where you have a cross-border transaction, a dealer here, a dealer in Europe, and subject to potentially different reporting requirements. And I think there's two variations on this. One is where the two entities are not members of the same SDR. That's the first thing. And then the second thing, and going to Kim's suggestion from a different area, what if the regulators have different reporting requirements for transactions that they're not completely mapped with each other? So I guess I have a question both for the infrastructures, the potential SDRs in the panel, how you are going to deal with this type of situation from a business perspective, and then for example, the intermediaries, how you view this situation as working out, and how the regulators should best address these issues.
Pete?
I guess the nice thing about the SDR situation is that there's going to be a race to the top, or the opposite of whatever